every time. Good afternoon, everyone, and welcome to the Assembly Committee on Commerce and Labor. Secretary, will you please take roll?
Assemblywoman Backus. Assemblyman Carter.
Present.
Assemblywoman Duran. Assemblywoman Hardy. Assemblywoman Howdigi. Assemblywoman Kasama. Assemblywoman Monroe Moreno. Assemblyman O'Neill. Assemblywoman Torres. Assemblyman Yeager. Assemblyman Urick. Chair Marzola.
I am here. Please mark Assemblywoman Monroe Moreno absent excused and mark the remainder of the members that are not present once they arrive. Thank you, everyone that is here today in Carson City and anyone listening over the phones today. In our agenda items, we will be hearing 4 bills: Assembly Bill 363, Assembly Bill 364, Assembly Bill 392, and Assembly Bill 442, and we will also be having a work session. I will be taking the bills out of order, and we will be having the work session towards the end of our meeting today. Before we get started, I'd like to make a few housekeeping announcements. Please turn off all of your electronic devices, including your computers, or silence them. You don't have to turn them off. If you wish to testify, please sign in at the table by the door. If you have handouts for the committee, please provide 20 copies to the committee secretary prior to your testimony. I expect courtesy and respect in all our interactions, even if we may not agree. With that, we will move to our first agenda item. We will be hearing Assembly Bill 392. I will now open the hearing on Assembly Bill 392, which makes various changes relating to property. Assemblywoman Kasama, you may begin when you're ready.
Thank you, Chair and committee members, for allowing me to present this bill to you. I'd also like to thank my co-sponsors, Assemblywoman Howdigi and Assemblyman Gurr, for this bill. Before I begin, I wanted to point out that Section 1 of the bill has to do with deceptive trade practices regarding a 40-year listing agreements, and Section 2 is entirely unrelated to Section 1 and has to do with some cleanup language needed in Chapter 645 for real estate regulations, which will be covered later in the presentation. So they both have to do with real estate issues, but completely unrelated. So it's kind of 2 for 1. As many of you know, I have been the office manager for the Summerlin office of Berkshire Hathaway Nevada Properties. Being in real estate is almost like being an elected official. Every day is a surprise with what awaits you. There's never a dull moment, as you know. So last year it came to my attention through our corporate broker, Forrest Barbie, that we had unusual liens showing up against properties we had listed for sale. What was happening was one of our agents met with an owner to list the property. They provided a comparative market analysis, spoke to the owner about their marketing plan, and costs involved to sell their home. An agreement was reached. Our agent was hired. The agent then proceeds to market the home, hold open houses, and eventually an offer is received, negotiated, and accepted. Now escrow is open with the title company. The title company prepares a preliminary title report and outlines all the liens on the property. For example, property taxes, HOA encumbrances, trash and sewer liens, the current owner's mortgage. Some liens continue to run with the property taxes, and others are extinguished at closing, the seller's mortgage. What was discovered was a lien from MV Realty with a 40-year listing agreement that was a lien on the property, binding to the heirs and the estates. Imagine, your kids have to work with a company maybe 30 years from now to whom they have no knowledge of, let alone if that company is still even in existence. When the agent and title company ask the owner about this lien, they respond they have no idea about it. What MV Realty does is they advertise on the internet they will provide a comparative market analysis to the owner and pay you $500, $1,000, whatever the amount might be, to provide this analysis to you. Keep in mind that any real estate agent does this for free. I have been on their website, and it is very much buried deep in their advertising what they are doing. They simply say by providing this report and money to you, when you decide to list this property in the future, will you consider using them to list the home? Their paperwork is expertly drawn up. So they do have you sign an agreement that they also have you notarize online that you agree to this. It does show on the paperwork that it is a 40-year listing agreement, but it is not clear in any of their advertising. It just shows up on the short form notarized document. The company is preying on owners that are looking for quick cash, and it is a deceptive trade practice. When our agents get ready to close on a property and the title company contacts MV Realty to get a lien release, they want a 3% commission to release the lien. Of course, our agent gets no commission. We now end up in negotiations with this company to obtain the lien release. Keep in mind that they have not been involved whatsoever in the sale process and have made no contribution to the closing of the home. This bill is to stop the egregious trade practice. I have uploaded some exhibits on Nellis, and further, and there is, in addition, there's an amendment from the Lyon County, which all of the NACO counties agreed to, changing on page 1, line 3, changing the word from clerk to recorder, just for clarity on that. And welcome, Sylvia. I just wanted to point out, too, that recently there was an Inman article, and Inman is a trade publication that is read quite much in the real estate industry, and it reported there that there are currently 4 lawsuits being filed in different states against this. It's being reported to the Federal Communications Commission. In addition, not only the 3% I mentioned to you they want, and it's based on the value of the home or the selling price on the home, whichever is greater, and MV Realty decides what the value of the home is. And furthermore, if there's no buyer broker involved, they want 6%. So with that, I'd also like to turn this over to Sylvia Smith with the title company, and she's going to share some insight as to what is happening on the title side. Thank you.
Good afternoon, Chairwoman Marzola and members of the Assembly Committee and Labor Committee, Assembly Commerce and Labor, sorry. My name is Sylvia Smith-Turk. I am past president of the Nevada Land Title Association, currently a member of the Nevada Land Title NLTA for short, Legislative Committee, and I co-chair the American Land Title Association State Legislative and Regulatory Action Committee. That's a mouthful. And on behalf of NLTA and ALTA, I would like to thank Assemblywoman Kasama for bringing our portion of this bill in front of this committee. I am addressing strictly Section 1 of AB 392, which the Assemblywoman gave you a little bit of background on. In our industry, these agreements are commonly called NTRAPs, which is a non-title recorded agreement for personal service. So you'll see that word intermingled in the articles, different saying. We call them NTRAPs. Generally, they're recorded, the agreements are recorded in the real property records that provides notice evidencing the owner's agreement for future service in exchange for a small upfront monetary compensation. It's paid to the owner when they sign these agreements. And regardless of whatever you want to call the agreement, they're recorded even though in reality they should not constitute an interest in the real property. It's basically payment for a future service that they agree to list at some time in the future. These recorded memorandums basically create a 40-year term, a listing agreement with that particular company. And there is more than just MV Realty. We've seen a couple of different companies in Nevada currently that are operating and using these. The agreements obligate the current owner, again, to a future, and it attempts to bind any successor owner of the property as well to these 40-year contracts. The act of recording it really for our industry, it creates a long-term barrier to the sale or refinancing of the real estate, and certainly can hamper estate administration where you're passing the property on, because they purport to run with the land and basically attach to it for that 40-year term. If the homeowner, as Assemblywoman Kasama indicated, does not list with that company, they are still obligated to pay anywhere from a 3 to 6% commission to that company. That would come into play if they were to sell as a FSBO or for sale by owner. Actually, if they lose the home in foreclosure, they're still indebted to that, while the actual recorded document would be wiped out in the foreclosure, but the debt remains. If there's any kind of sale that's not done with a real estate agent, they still owe the money. Whether they did it themselves, went to a different company, they still owe it. And again, as Assemblywoman Kasama indicated, these agreements, the commission is calculated on the property's value at the time that they entered into the agreement. So in our instance, as most of you know, our median home price in Washoe County a year ago was $620,000. Now it's down to $519,000. So, but yet they would still be committed to pay it at whatever they deemed the value at that time. The agreement, because it purports to run with the property, is very concerning to the title industry for many reasons. If for some reason it were to be missed in a title search, obviously we would have to, under the purpose of title insurance, it would become the obligation to pay it. But if someone does a deed themselves, or like an inter-family or estate administration, it stays with the property, a deed upon death. If that language is in there, this agreement runs with the property, so it now indebts someone that had no idea that was out there. There are over 800 of these agreements that are recorded currently in Nevada. The bulk of them are Clark County, but they're in all the counties. Washoe, pretty much all the rurals have at least 5 or 6 of them. I can get that list for you if you would like to see more information on where they're recorded. So they are out there in the rurals, they're everywhere. Our company, we recently closed a sale transaction. We had an owner that had bought the property in 2013. He had gone through a divorce, refinanced in 2021, signed one of the NTRAP agreements in 22, accepted a very small payment. I believe it was around the $1,300 mark. He was forced to sell the property earlier this year. He did go directly to an investor, so there was never a listing, never any of that. They held him to, because he sold it, he had to, he was in foreclosure and going to lose the property. The company demanded $16,000 to release the recorded memorandum, which of course we had to insist on because we can't insure a new buyer or their lender. So it was a tough deal. I spoke to another local title company. They handled a refinance agreement or a refinance loan for a customer that had entered into one of these agreements, even though the document said they would agree to subordinate if someone were to do a refinance, meaning they would give up their first position and subordinate to a new deed of trust. The lender required that agreement be removed from the property. They would not accept a subordination. That borrower, unfortunately, was in financial distress as well and facing foreclosure. So in order to get the new loan, he had to pay $24,000 to this company to get that document released. These are just a couple of examples that we see from our side, from title insurance and settlement on the escrow, the closing side. They create hurdles and they create costly clouds on the title to real property. We're concerned that while right now it's all great that we can find them and we can get a response and get a demand and get a release, that maybe in 5 years, maybe they're not around. And then what happens? And that's going to require that property owner to do a quiet title action, which is a court proceeding that can take anywhere from 6 months to a year and cost about $5,000 to $10,000 depending on the action. So for us, it's just going to create the issue of how do we clean them up in the future. This bill, the way that it was written, will prohibit future agreements of this type. It will deem them void and unenforceable. We've also, LCB helped write the notice. Any previously recorded, those 800 agreements that are currently of record, it does give them an option to be able to record something within a year. Otherwise, they'll be deemed void and unenforceable as well. It was modeled after the, I don't know how many of you were around 2011, we did the private transfer fee bill, so it was modeled after that in that same section, Chapter 111. Similar bills to what we have passed. The most recent was Utah. Probably just a couple of weeks ago, they passed. Georgia and North Dakota that I know of as of now. Other states, their attorney general's offices have filed lawsuits against the companies. Florida, Massachusetts, Pennsylvania, and North Carolina. So this is a nationwide issue that we're trying to address. So with that, that concludes my testimony. We respectfully ask that you give consideration to that section and pass it. And I want to thank Assemblywoman Kasama again for assisting us in bringing this important matter forward. And I'm happy to answer any questions as to Section 1, if you have any.
Thank you for your presentation. Assemblywoman, are you going to go through the bill?
Yes, I can go through the bill here. So in Section 1, what I wanted to point out, Section 1, line 5, it does say there, so the way, trying to avoid costly lawsuits from the state, I try to figure out what is a quick way that we can deal with this because people are being hurt by this. And so the simplest way that I thought was that we limit listing agreements to 1 year. So that is in Section 1, number 5. You see it's limited to 1 year. And then Sylvia went over some of the other sections there, but I'll draw your attention to under Section 1, 3, and 4. That language is what title is looking for too, because as she said, some of these agreements are already recorded. So this gives a way for them to deal with the ones that are already recorded, and then it gives a date where it's prohibited from then on. And I think that really is kind of the short story on the sections that are most important. The rest of these are really kind of title requirements that they suggested be in the bill. And so I would like, if we have questions on, since the two sections are unrelated, if anybody has any questions on these, we stand ready for that on Section 1.
Committee members, are there any questions? Assemblywoman Hardy.
Thank you, Chair. Thank you for this bill. When I was talking with the Assemblyman about this, I was shocked, as I'm sure many people are, that this is going on and like these companies are getting away with this. So my question just is, as far as the 800 that you mentioned of these agreements, is somebody reaching out to these homeowners and whatever to let them know what's available to them, or saying this law passes that someone would be in contact with those people so that they know what's available to help them?
So Sylvia Smith-Turk for the record, to Assemblywoman Hardy through Chairwoman Marzola.
And you can go direct.
Okay, thanks. We do not have a way to notify them. It really would be the recording of the service agreement that's called for, I believe, in Section 3A, where it talks about that, where they would be required to record that document in plain language so that it's very clear. But beyond that, no other than the bill, and hopefully as an industry, just getting the word out.
Assemblywoman Backus.
Thank you so much. The hazard of finding which mic is mine. I just had a quick question because this just seems, I don't know, so unconscionable to me that I was, and I understand how the bill was written, that it covers, it's broad. It covers any type of service agreement with exceptions that maybe something else comes down the pipeline. But I was curious because for me, I would have just, if there's lawsuits, AGs getting involved around this country, of just deeming these type of agreements void and unenforceable if they exceed the 40 years. But then I noticed under subsection 3 that the service agreement prohibited pursuant to section that's recorded on or after October 1st, 2023 is void and unenforceable. And so I was kind of curious, and it may be a question for legal, even though I'm an attorney. I was just trying to figure out why we just can't make these just void and unenforceable. Sorry about the runaround.
Sylvia Smith-Turk for the record. Assemblywoman Backus, we would absolutely love that and would love to be able to have them just deemed unenforceable. I believe when it went to LCB, they just mirrored the language under the private transfer fee bill that was done in 2011. But legally, if they could be deemed that, we would absolutely love that.
And I'll have legal chime in as well. Thanks.
Thank you, Madam Chair. Sam Kwas, Committee Counsel. That is correct, that the provisions there which require the extra notice there are based on, and that's subsection 6, is based on NRS 111.870 regarding the private transfer fee obligation. As far as the issue of whether or not all these things could just be deemed void right now, that's something I'm really not prepared to address right now. I would like to look into whether or not there are other legal issues that would preclude that. And so I'll look into that and get back to the committee.
Thank you. Committee members, any additional questions? Assemblywoman Torres.
Thank you, Chair, and thank you, Assemblywoman, for bringing forth this legislation. I wanted to see if you could just talk a little bit about Section 2, because I don't think that was covered really in the bill presentation regarding property managers. So if you could just talk a little bit about the genesis of that and walk through that part of the bill.
Yes, I was going to do that after questions were done in section 1. Do you have a question on 1?
Why don't you go ahead and go through the section 2 now?
Section 2, okay. But, just before I leave section 1, and I know some of you even use the word unconscionable, and I just thank you because I think this is something we want to stop as quickly as possible. And like I said, at the beginning, being in politics and being in real estate, every day is different. And when this popped up this last summer, I was just floored and astounded with some of my agents that, we're working hard on things, and then these issues came up. So I appreciate your certainly support on this. And thank you, Sylvia. You came in the nick of time. You were probably running up the stairs there, so thank you so much. In regards to Section 2, now Section 2 is completely unrelated. It has to do with Section 645, which is the real estate section in statute, and it's looking at some cleanup language for that. And I'd like to return the remarks over to Forrest Barbie, who is the corporate broker from Berkshire Hathaway. He'll walk us through the cleanup language if he is on the line. He was going to zoom in. I don't see him. But if not, I have the information. Do we have anybody on the line, Forrest? You want to
talk about agency, which is
Sure.
the next section.
Okay, so with that, I'd like to introduce Tiffany Banks. She is General Counsel for the Nevada Realtors, and she will step in and assist. Thank you.
Thank you, Assemblywoman. Good afternoon, Chair and members of the committee. My name is Tiffany Banks, and I'm General Counsel for the Nevada Realtors. We're happy to be here today alongside Assemblywoman Kasama and help explain Section 2 of AB 392. While I am only addressing the language in Section 2, we are in full support of Section 1 of this bill as drafted today. We would like to thank the bill sponsors for their hard work on this important piece of legislation. Section 2 sets forth certain duties of a person who acts as a property manager while performing his or her duties pursuant to a property management agreement. A property management agreement is a legally binding contract between a client and a broker in which the broker agrees to accept valuable consideration from a client for providing property management for that client. Property management specifically means the physical, administrative, or financial maintenance and management of real property, or the supervision of such activities for a fee, commission, or other compensation pursuant to that property management agreement. It is important to note that in order to hold a property management permit, you have to be a Nevada real estate licensee. The intent of this bill and the language provided is to clarify the relationship between the property manager and owner and not intended to set forth duties creating a separate license for property managers. The language contained in Section 2 closely mirrors the language already in existence under NRS 645.252, setting forth duties of a licensee acting as an agent in a real estate transaction. Where this differs is that it expands in subsections 4, 5, and 6 additional duties and clarifies that those duties are only specific to those property managers, such as accounting for all money the property manager receives. Existing law already sets forth actions that may be taken if unlicensed property management activities are conducted which require a license, so that is not discussed here in this bill. The Nevada Realtors will continue to work on further clarifying language in this section, and we are committed to working with Assemblywoman Kasama on legislation that protects consumers while clarifying responsibilities of those engaging in property management activity in Nevada. And I'm happy to answer any questions or walk you through any specifics of Section 2 as they outline the duties today.
Thank you, and thank you for going through that section. We will take additional questions. Committee members, any additional questions? I don't see any, so we will move to support testimony.
And then we haven't touched on this yet. Okay. Let me touch on this. Okay.
If you guys want to get up and give others a chance. Thanks. We will take testimony in support of Assembly Bill 392. Is there anyone here in Carson City? Please remember to state and spell your name for the record. You have 2 minutes.
Good afternoon, Chair Marzola. For the record, Dylan Keith, DYLANKEITH with the Vegas Chamber. First, we would like to thank the sponsors for bringing forward and noticing this important issue and finding a solution. This is an egregious practice, and we want to maintain the reputability of one of our major organizations in the state. And for that reason, we are in support, and we ask for your support as well. Thank you very much for your time.
Thank you, Madam Chairman and members of the committee. For the record, Mary Walker, representing Lyon County. I just wanted to say thank you very much to Assemblywoman Kasama for accepting our very small one-word amendment. Thank you.
Thank you for your testimony. Is there anyone else here in Carson City wishing to testify in support? I don't see anyone. Broadcast, is there anyone on the line wishing to testify in support of Assembly Bill 392?
Callers, if you'd like to testify in support of AB 392, please press star 9 now to take place in the queue. Caller with the last three digits 980, please press star 6 to unmute. Caller with the last three digits 980, you are unmuted and may begin.
Well, good afternoon. This is Forrest Barbie. I was supposed to be on earlier, but I was muted and could not get unmuted. And so I have a short statement here that I was going to provide for Haiti Kasama. So thank you very much for the committee in looking at this bill. So the foundation for Nevada Designated Agency as currently practiced was a result of the passage of Senate Bill 403 during the 1995 Nevada Legislative session. At that time, there was only a need to address brokerage agreements in the context of real estate transaction, since property management was not directly addressed with the inception of statutory agency. The 1997 legislative session addressed property management with the passage of Senate Bill 248 that established a framework for the property management beginning in NRS 645.6052, as well as the requirements for a new property management permit. Senate Bill 315, Section 7 from the 2005 legislative session properly modified the definition of brokerage agreement in NRS 645.005 to exclude property management agreements, primarily because NRS 645.320 prohibits brokerage agreements from containing an automatic renewal provision clause. However, Senate Bill 69 in 2007, the legislation session modified the definition of or actually added the definition of agency in 645.0045, which unintentionally limited express agency to one created by a brokerage agreement. That was really an oversight and should have been a brokerage agreement or a property management agreement. It seems that when the 2007 legislature passed Senate Bill 669, it didn't take into consideration the change in that definition. Consequently, there's no evidence from the 2007 session minutes or meetings that the legislative intent was to exclude property management agreements
Mr. Darby?
from documents.
Mr. Darby, can you please
Yes.
wrap up your testimony? We appreciate your testimony and support, but your 2 minutes has ended.
I'm sorry, then that's fine right there.
Thank you. Broadcast, is there?
We're good. Thank you very much.
Thank you for calling in. Broadcast, is there anyone else on the line in support to Assembly Bill 392?
Callers, if you've recently joined and would like to testify in support of Assembly Bill 392, please press star 9 now to take your place in the queue. Chair, we have no more callers in support at this time.
We'll move to hear testimony in opposition to Assembly Bill 392. Is there anyone in Carson City wishing to testify in opposition to Assembly Bill 392? I don't see anyone. Broadcast, is there anyone on the line wishing to testify in opposition?
If you'd like to testify in opposition to Assembly Bill 392, please press star 9 now to take your place in the queue.
Did you win?
Chair, there are no callers wishing to testify in opposition at the time.
Thank you. We will move to testimony in the neutral position. Is there anyone here in Carson City wishing to testify in the neutral position to Assembly Bill 392? I don't see anyone. Broadcast, is there anyone on the line wishing to testify in the neutral position?
If you'd like to testify in neutral to Assembly Bill 392, please press star 9 now to take your place in the queue. Caller with the last three digits 000, please press star 6 to unmute yourself.
Good afternoon, Madam Chair, members of the committee. Sharath Chandra, SHARATHCHANDRA, Administrator for the Nevada Real Estate Division. Just here to provide neutral testimony and answer any questions the committee may have. Thank you.
Thank you for your testimony, and I don't believe the committee members have any questions.
Chair, we have no more callers in neutral at this time.
Thank you. Assemblywoman, would you like to give some final remarks?
Just wanted to thank everybody so much. I think we can agree that this is a really serious issue, and we need to get this passed for our consumer protections. And just thank you to all my co-sponsors and my supporters with their testimonies as well. Thank you.
Thank you for your presentation and bringing this bill forward. We will now close the hearing on Assembly Bill 392. 1 minute recess. Committee will come back to order. We are actually going to go into our work session before we call our next bill. We will conduct a work session to take action on measures the committee has heard in previous meetings. It's not customary for the committee to take testimony or otherwise rehear the bills during the work session. However, I may invite a witness to come forward for clarification or question during our consideration of the measure. We will begin with Assembly Bill 216. I will now turn it over to our policy analyst, Ms. Thomas.
Thank you, Chair. Assembly Bill 216 revises provisions governing travel insurance. It is sponsored by Assemblywoman Gorlow. It was heard by the committee on March 8th. There are 9 proposed amendments, and they were requested by Samantha Sato, Director of Legislative Affairs and Operations with Carrera, Nevada. The first is to revise the definition of blanket travel insurance in Section 4. The second is to add language to specify that cancellation fee waivers and travel assistance services are not insurance. The third is to revise Section 6 of the bill to change the term civil to civic in subsection 5 and include any trust or the trustees of a fund established, created, or maintained for the benefit of and covering members, employees, or customers of one or more associations described in subsection 7. Fourth is revise the definition to fulfillment materials and specify in section 7 and specify that the documentation may be provided or sent to the purchaser of a travel protection plan. The fifth is amend section 11, line 29 to remove the words of travel insurance. The sixth is revise the definition of travel administrator in section 15 to provide that the term does not include a person working for a travel administrator to the extent that the activities of the person are subject to the supervision and control of the travel administrator. The seventh proposed amendment is revise section 21 to remove the requirement that a person hold certain licenses or registrations in order to be issued a license as a producer of limited lines travel insurance. The eighth proposed amendment is to amend sections 21 and 29 to clarify that 1, a producer of insurance licensed in certain lines of authority may act as producer of limited lines travel insurance, and 2, a producer of insurance licensed for property and casualty insurance is not required to be appointed by an insurer to act as a producer of limited lines travel insurance. And the ninth proposed amendment is to amend section 37 to clarify that an insurer is required to pay the tax on insurance premiums for travel insurance premiums paid by a primary certificate holder who is a resident of the state and who elects coverage under a group travel insurance policy.
Thank you. Members, are there any questions? I don't see any. I'll entertain a motion to do pass.
So moved. Amend and do pass.
Motion to amend and do pass.
So
Didn't I
moved.
say that? Oh. I have a first from Vice Chair and a second from Assemblywoman Torres. Is there any discussion on the motion? All those in favor say aye. Aye. All those opposed say nay. Motion carries. I will assign the floor statement to Assemblywoman Garlow. We will move to Assembly Bill 321. Ms. Thomas, you may begin when you're ready.
Assembly Bill 321 makes various changes relating to public safety. It is sponsored by Assemblyman Carter, heard on March 27th. There are two proposed amendments by Ryan Bellows with NV Energy and Carolyn Turner with the Nevada Rural Electric Association. The first is to amend subsection 3 of section 8 of the bill to revise the dates of the prescribed phase-in period by which certain percentages of the foil balloons sold, offered for sale, or manufactured by a person must become compliant. And the second amendment is to add two new sections of the bill to revise NRS 200.471 and 200.481, which establish the crimes of assault and battery respectively, and provide for enhanced penalties for commission of those offenses against certain persons under certain circumstances, to provide for enhanced penalties for the commission of an assault or battery against a utility worker under certain circumstances.
Thank you. Members, any questions? I'll entertain a motion to amend and do pass on Assembly Bill 321.
So moved.
I have a first from Vice Chair Howdigee, a second from Assemblywoman Torres. Okay. Any discussion? I don't see any. All those in favor say aye. Aye. All those opposed say nay. Motion carries. I will assign that floor statement to Assemblyman Carter. Next, we will go to Assembly Bill 343.
Assembly Bill 343 revised provisions relating to occupational therapy. It is sponsored by Assemblyman Miller. It was heard on March 31st. There is one proposed amendment by Paula Cook, the president of the Nevada Occupational Therapy Association, to amend subsection 3 of section 6 of the bill to remove an equivalent foreign educational program and replace it with a comparable foreign educational program.
Thank you. Members, any questions? I don't see any. Oh, go ahead.
I just wanted to make note, I'm yes to get out of committee and reserve the right on the floor. Thank you.
Thank you. I'll entertain a motion to amend and do pass on Assembly Bill 343.
So moved.
I have a first from Vice Chair Howdigee, a second from Assemblyman O'Neill. Any discussion on the motion? I don't see any. All those in favor say aye. Aye. All those opposed say nay. Motion carries. I'll assign the floor statement to Assemblyman Miller. I will now open the hearing on Assembly Bill 363, which revises provisions relating to professional and occupational licensing. Assemblywoman Miller, you may begin when you're ready.
Thank you, Chair Marzola and members of the committee. I am Brittany Miller, representing Assembly District 5 in Clark County. I am sponsoring Assembly Bill 363, which is provided in skeleton form. Now, what skeleton form means is that it impacts many chapters. So instead of having to print loads of paper for the redundancy that would just be repeated throughout each chapter, they just present the bill with its intent in skeleton form. Ultimately, Assembly Bill 363 requires considerations on the aspects of the criminal history of an applicant that certain professional and licensing entities are authorized to consider in determining whether to issue a license to an applicant. In other words, a regulatory body cannot deny a license to an applicant solely on the basis of their criminal history. The burden of proof is on the state to show the applicant is not qualified based on a multi-step process for boards to follow in assessing an applicant's criminal records. Nearly 1 in 3 U.S. adults and 1 in 4 Nevada adults has a record in the criminal justice system. The Institute of Justice reports that a person re-entering society after a conviction faces limited employment opportunities because of licensing. Beyond struggling with the ordinary cost of licensing, former offenders often encounter special restrictions that ban or limit people with criminal records, even records involving irrelevant or long-ago violations. The Institute of Justice ranks Nevada as the worst state in terms of licensing burdens based on the number of jobs requiring licenses and the number of hurdles for job seekers to overcome, even for low-paying occupations. According to the Institute for Justice, in another recent survey, 2 in 3 formerly incarcerated people were unemployed or underemployed 5 years after release. What many people don't realize about me is that I once was the director of a prisoner reentry program. And while it was funded by the State Department of Justice, the majority of the funding actually came from the Federal Department of Labor. The reason for that is because, without question, secure employment is one of the highest factors in reducing recidivism. But interesting enough, according to a recent study just put out by Arizona State University, they reported that states with a higher licensing burden also have higher rates of recidivism. We have the opportunity to address a twofold issue: reduce recidivism while putting more Nevadans back to work, including in some of our occupations with labor shortages. Because let's consider the reality of arrest, conviction, and incarceration. The majority of people will eventually be released from prison. Moreover, a larger group impacted are those who were arrested without conviction. They all need solid employment with a minimum of a living wage to be self-sufficient, provide for their families, and even pay restitution or court cost. Again, one of the most important factors in predicting their success is employment. In my experience, I saw many people who were in prison who in fact needed training or education in order to qualify for certain jobs. But what I also saw were plenty of individuals who had already had college degrees, certificates, and experience in stable careers and skilled employment. In addition, the rationale for criminal records requests, whereby licensing boards seek robust information to advance the health and safety of the public, is misleading and confusing. There is no available evidence demonstrating that having a criminal record is related to poor occupational performance or low-quality services. Simply having a criminal record does not predict an individual's ability to perform an occupation. However, the bill does acknowledge that there may be certain risk factors to consider. In other words, we would not suggest licensing a person who had been convicted of elder abuse to work in a nursing home. Instead, the bill requires that each individual receive scrutiny on a case-by-case basis to determine whether or not the actual offense has a direct link to possible vulnerabilities or risk. To address this barrier in occupational licensing, the legislature passed AB 319 in 2019, which authorized a person to petition certain regulatory bodies for a determination of whether the person's criminal history would disqualify the person from obtaining a certificate, license, permit, qualification, or registration. The person may petition a regulatory board before obtaining any required education or paying any required licensure fee. The bill provided that not later than 90 days after a petition is submitted to a regulatory body, that the body shall inform the person of its determination. In June 2020, the Sunset Committee reported the following boards received petitions to review an applicant's criminal history. For the barbers, there was 55 petitions, cosmetology, 161 petitions, court reporters, 1 petition, dental, 1, medical, 4, and nursing, 39 petitions. 22 boards reported to the Sunset Committee that there are no clearly defined list of crimes that would automatically preclude a person from licensure, and the overwhelming process is to review petitions on a case-by-case basis with applicants to discuss the circumstances surrounding any criminal history prior to determination. Before we get into the details of the bill, again, I want to state that this bill is an opportunity to get our Nevadans back to work and participating as contributing members of society. We know workforce issues and barriers often affect a person's ability to do that, and it often affects all people of all walks of life. And so with that, I will turn this presentation over to my co-presenter, Attar Hasibullah, the Executive Director of ACLU Nevada, to walk us through the components of the bill.
Good afternoon, members of the committee. For the record, my name is Attar Hasibullah, first name spelled A-T-H-A-R, last name H-A-S-E-E-B-U-L-L-A-H. I'm the Executive Director for the ACLU of Nevada. my commiserations for having to see me twice in a 3-day span. So I will try to make the presentation as brief as possible to allow ample time for questions. The Institute for Justice, as Assemblywoman Miller mentioned, has published numerous studies on Nevada's occupational licensing standard. It's the ACLU's position that occupational licensing reform may be or should be the most bipartisan issue this legislative session. IJ specifically stated that in a study that they had released that Nevada earned an F when it came to protections for licensing applicants with criminal records. There's only 6 other states that have an F rating. Our hope would be that through the approval of this bill, we can start to move past an F grade and hopefully show up to future sessions with a much higher grade, and we can laud and applaud the work we've done here. As Assemblywoman Miller had mentioned, there were previous laws put into place that allowed for a predetermination process to occur when an individual had a criminal record and sought licensure. However, licensing entities are not bound by those determinations, and they may rescind those at any time. Those caveats completely undermine the purpose behind the petition process and render them meaningless. This bill addresses that problem. It creates a binding predetermination process so returning citizens can rely on the state's decisions related to their criminal histories when determining whether to invest time and resources into securing a license. It ensures boards are not considering old and irrelevant elements that don't bear on a person's ability to safely perform the duties of that occupation. And it provides people with a meaningful path to employment. That remains critical, and that's why this bill is here today. I'll now go over the technical specifics of the bill. I'm having a little bit of issues with my microphone, so I'm going to move down one seat. I'm not sure if it sounds... Oh, we'll share. All right, thank you. I'll briefly go over each of the provisions, and again, happy to take any questions as they come up. Section 2 of the bill lays out the definitions to be used by this bill to include the definition of potentially qualifying felony offense, and as amended, the definitions of deny an applicant. And deny, under this specific bill, would mean to deny, diminish, limit, suspend, revoke, refuse to renew, or otherwise withhold state recognition for a license. Section 2 also details the disclosure and consideration requirements for licensing boards. Notably, this section includes a prohibition on arrests which did not result in convictions for potentially disqualifying felony offenses or records which were sealed. The reason why this is important is the ACLU of Nevada has been informed multiple times that while there may not have been any conviction, there may have simply been an arrest. Licensing boards have denied otherwise qualified applicants the ability to receive a license simply based on an arrest. Section 4 of the bill lays out parameters for disqualification of licensure based on an applicant's criminal history, including directly tying the disqualification into the duties and responsibilities of the license being sought. A showing that the applicant has not been rehabilitated and that the license would pose a direct risk to public safety because the applicant cannot perform the duties and responsibilities of the occupation. That standard actually sets a requirement that disqualification would only be possible through clear and convincing evidence, or clear and convincing evidence exists of those criteria. And according to the United States Supreme Court, that definition means that the evidence would be highly or substantially more likely to be true than untrue. Section 4 also creates criteria that the boards are to consider when assessing rehabilitation, taking a totality of the circumstances approach to a prospective licensee. So no more would they be able to summarily deny a license for no reason. It's an individual consideration that, again, will get more people potentially back to work. Section 5 states that the preliminary decision process would occur, but it would be bound in a requirement. The preliminary decision process would save time, energy, money, and allow individuals who are seeking licensure to understand what they're going to have to experience before they end up going through the process of moving forward with such. Although Nevada currently allows workers to receive a pre-application decision to determine whether their criminal history is disqualifying, boards are not bound by these decisions. and people therefore cannot rely on pre-application decisions to know whether they should invest time and money into pursuing a license. A licensed applicant may be initially told by a board their criminal history is not disqualifying, invest the time and money into necessary training, only to later be denied by the same board. Section 5, subsection 2 lays out the written notice provisions associated with the denial and creates a right to an informal meeting with an executive director or their designee if a licensing board does not have one in the event a denial occurs. Subsections 3 through 7 of Section 5 lay out associated provisions related to that informal meeting, including specific requirements for applicants who receive a preliminary denial and make such a request and the timelines associated with such meetings. Section 6 then further bolsters that provision by laying out the parameters for what the informal meeting would do, including items related to character assessments, specifically to bolster the individualized assessment that goes into each license. And again, that's the point of the bill in large part, an individual assessment where the burden post-denial is not held by the applicant. We've seen time and time again, individuals are attempting to better their lives, seek an occupational license, they're denied their license, and the burden is on that applicant to move forward and attempt to challenge that. Most of the time, if you're seeking an occupational licensing in that regard, you do not have the money to hire an attorney to go in and combat that in court. So this would shift the burden to the board that is denying the license. Section 7, subsections 3 through 7 lay out the provisions for a preliminary denial and provide recourse for applicants in the event of such a denial. If the preliminary decision is adverse to the applicant or is clearly erroneous, the regulatory body may deny a license to the applicant on the basis of that history after notice and an opportunity for a hearing is provided within that section. Again, it provides some ability for recourse. No simple denials, no goodbye, try again in the future, but we're not going to tell you what you did wrong. We're not going to tell you what the issues were. These are individuals under this provision who in many instances have been denied a license without even being convicted of anything. We've seen licensure denial based on arrest alone, which means nothing. We've talked time and time again over the course of the last 48 hours at a bipartisan level about the presumption of innocence, but it doesn't seem to always apply when it comes to licensing boards. The fact that we have an F in this is something that can be easily fixed through this specific provision in this bill. Sections 8 and 9 of this bill make some conforming changes, including a requirement within subsection 7 that a licensing board shall post on its internet website its licensing requirements and an explanation of the procedures by which the regulatory body may deny a license to an applicant on the basis of their criminal history. That becomes important right now because, again, we don't have notice provisions in place that are sufficient. Section 10 makes conforming changes specifically addressing the definition of good moral character. And again, this is a skeleton bill. It could be widened as needed to apply to each individual board. But good moral character is one of the most arbitrary terms out there. For those that are attorneys like myself, we've had to deal with this with the Nevada bar and every other bar exam we've taken, and many others have had to deal with these issues as well. But what does good moral character mean? Well, under the law as it stood, this particular bill addresses some of those issues by removing provisions 1 through 3, has not been convicted of a felony, misdemeanor, or gross misdemeanor, and specifically this was with respect to landscape architecture, but again, a lot of the language has been extrapolated, as you all know, via other sections within NRS that should have probably been more universally applicable, but ends up applying or falling within a subsection, and then we pull from there. Our body of law here is still a work in progress, as we might say. Those are the overall provisions of the bill. I am happy to answer any questions. I'd also give 2 caveats before we do that. First, we had about 75 ACLU members who had said they were in desire of calling in today. I instead asked them to submit a letter, so we submitted that for the record. I do recognize the time constraints that this committee is under, and so those will be available for you, but I wasn't intending on torturing you today with such. Secondarily, and probably more importantly, there's going to be opposition from licensing boards. That's to be expected. The purpose and the reason why this bill is forward is to change that process. These boards have a lot of power right now, and the people of Nevada don't. The people who are seeking these licenses don't. They're denied the ability to earn a lucrative living. State boards that issue occupational licenses have been tremendously empowered. And this isn't a knock on them as individuals, but the structure that we have in place places an onus on an individual attempting to seek work after they've fulfilled every term that they needed to get back into the workforce. And instead of being greeted with an individual determination and the opportunity for an occupational license that might better their future and the future of their family, they're denied that license, and all they're told is, you can seek an attorney if you have an issue. That's insufficient, and we need to get more people back to work. So with that, I'm happy to answer any questions that the committee might have.
Thank you, and thank you for your presentation. We'll start with Assemblywoman Duran.
Thank you, and thank you for this presentation. I appreciate that. I work with some companies as well, and if people are arrested and they are just charged, they, automatically think they are guilty and keep them out of work, and it is a big problem. But I also wanted to just ask for on Section 5, or Section 5, where is it? Section 5, number 3, as well as on Section 7, number 5. You're only giving them 15 days to appeal that. Why is that? I mean, with mail and stuff like that, can you, or even add electronically in there? Because I think sometimes, as they call it, snail mail is there. So unless it's a certified receipt that you're seeking that they do that, I was just curious to see if electronic can be put in that as well.
In crafting the language for the bill, for the record, Atar Hasibullah, Executive Director for the ACLU of Nevada, in crafting the language of the bill, it was important for us to glean from best practices in other states and what they've done. Part of the reason for the expedited timeline there was specifically to ensure the process moves along. If it ends up being a scenario where it's 30, 60, or 90 days or something that's longer, we might end up extending the entire period of time out. Really, for these specific initial denials, when you're seeking it on the front end, a preliminary decision, the goal is to have that come as fast as possible. We've laid out the parameters for what that looks like, and I recognize there will be some arguments made with respect to public safety, right? That's often something that comes up for advocates for excessive amounts of regulations as it deals with occupational licensing, but the issue becomes you have a conflict. A court of competent jurisdiction has deemed you fit to return to work. We've established the parameters for what that looks like, and yet a board may be in a position where they're stringing someone along for an excessive period of time. And so the purpose of that 15-day period was to keep the ball rolling and allow that process to move as expeditiously as possible.
Would you be able to put electronically in there as well? Because I think that as well is probably a better practice, because most of us do get email, and I think some of us respond to that as well.
Thank you for that question, Assemblywoman, and we'd be more than happy to amend that in as an additional option to expedite the process. Thank you.
Assemblywoman Torres.
Thank you, Chairman. Thank you for the presentation, Assemblywoman and Director. So I guess my question is, one of the issues that I had heard from talking to different constituent groups is that the question, though, the way it reads right now is if you have been accused, charged, or convicted. I don't know that this bill addresses those that have been accused. So would there be some consideration to address that, or maybe I'm just reading it wrong, but it looks like it's only if you have been charged or convicted. Thank you.
For the record, Atar Hasibullah, Executive Director for the ACLU of Nevada. Assemblywoman, I think that it goes beyond that, because the actual provisions that are in place with respect to the individualized determination don't create a blanket opportunity for an adjustment there. So what would happen is, as it stands right now, if somebody's been arrested, for instance, I'll use that as the example because that is a typical one we've seen. In fact, I received a leaked email that I shouldn't have received 3 weeks ago about a potential denial that's coming on a separate board. So note to all the boards that are in the room, be careful who you CC. Don't CC me if you're denying someone's license. But on one of those denials that came through, there was simply an arrest that came through, and it was denied. There was a licensure denial based on that. What we don't want to happen is that that's used as a precursor to engage in a denial of an occupational license. We do think that this bill addresses that because the provisions that are set forth lay out a very specific framework for what that looks like and allows the burden, again, to shift over to the state to justify its decision in denying a license versus forcing the applicant to move forward and having to do so.
Thank you. Quick follow-up, Chair. And maybe we want just something to preventing the boards from asking that question too specifically, because that is a question on licensing applications. And I've spoken to stakeholders that agree that you shouldn't have to answer whether or not you've been accused. I mean, many people have been accused of something. That doesn't mean that somebody's done it. And I know that's part of the wording of the question for a lot of our licensing boards.
Yes. Again, for the record, Atar Hasibullah, Executive Director for the ACLU of Nevada. We do think we can, if we need to tighten up Section 2, which deals specifically with the asks that are requested, we can go ahead and double check that language, make sure that's tightened. But it does preclude the ability to assess information or require disclosure of certain information within Section 2, namely that information which isn't going to be used in an effective way to make that licensing determination. But that does include some of those items, including arrests, juvenile adjudications, records that are sealed, and things of that nature.
We will go to Assemblywoman Backus next.
Thank you so much for your presentation. And I already had asked legal what a skeleton was, because I was like, that was my big question. But I just want to give a comment. What I really appreciate you bringing this bill, because another factor of this is so many people have offenses that are sealed and expunged, and you get in these predicaments when you're filling out these applications, usually under penalties of perjury, of whether or not you had ever had a history, like a criminal history. And so I really just appreciate the certainty in this, and I also like the section where the licensing boards are to post it on the internet so people would understand what those disqualifying criminal activity may be that would preclude them. So I just want to say thank you.
For the record, Atar Hasibullah, thank you.
Assemblyman O'Neill.
Thank you, Chair. Actually, I have three questions sort of dovetailed together, and part of them have already been addressed. On an arrest that's pending, trial is pending. The person has applied for a job, as Ms. Miller said, working at a elderly care facility, and they've been charged with elderly abuse, haven't been convicted. What would be, there's a dilemma there that if I read this correctly, the hiring agency could not delay, could not deny the application just because it's a pending court action. I think I may be reading part of this wrong. That's why my questions really are for clarification. Can you help me with that one first?
Yes, Assemblyman, for the record, Atar Hasibullah. From our vantage point, that wouldn't be the case. What would happen is, while that information wouldn't necessarily be required to be disclosed pursuant to the terms of that, the terms of the actual bill, the information that's associated with respect to the denial, would need to be on an individualized basis. I think what we could do to make sure that portion is clear from a vetting perspective would be to tighten that language if we needed to, if there's something pending. I don't know that was fully considered on the front end specifically, and so we're happy to make that adjustment if necessary. I think that's a good flag for us. And as we mentioned to others, we're always happy to work on additional language that clarifies things. Obviously, there's been, this is decades worth of cleanup here. So the skeleton as it exists right now that might be brought in and some meat added to it should probably include a provision like that makes that provision a little bit more clear if there is something that's specifically pending, because again, that's pre-adjudication as well.
I appreciate that. I truly do. If I may follow up, Chair, because when I was working, one of the divisions I was chief of actually handled a lot of these background investigations. And I will admit, I did not like us making the determinations for the various boards. I thought the information should go to the boards and let them make determinations. However, there are limitations when criminal histories are transferred from one agency or one person to another, that they have security requirements placed on the information, the material itself. And I'm not sure I see that addressed here. And I guess the question is, and maybe it's more to legal, should we look at, because I do think the board should make their own decisions, I truly do. But there are limitations placed by the FBI, by the feds, FBI, who and own the criminal history. on how that is handled. It's a lengthy process, so some of that should be brought in and looked at or in delayed implementation.
Assemblyman O'Neill, we're going to have legal
Thank you.
gives an explanation.
Thank you, Madam Chair, Sam Quas, Committee Counsel. So under this bill, the regulatory body and everybody else who this applies to, the regulatory body couldn't ask about it. They couldn't require an applicant for a license, and it only applies with the issuance of licenses. So you were referring to someone who applies for a job, or in that context. It only applies in the context of issuing licenses. But if there was a license associated with that, the regulatory body could not ask about anything except any aspect of an individual's criminal history except for information regarding potentially disqualifying felony offenses. And that's an offense for which a person was convicted, went to prison, and was released within the past 3 years. So in the scenario that you have presented, where it's information regarding an arrest, they couldn't ask about it. If they were to receive that information from some other source, because this just prohibits the regulatory body from requiring the applicant to disclose, if they were to receive that information from other source, they couldn't consider it when determining whether to issue a license.
Does that answer your question, or do you have an additional
I've
one
got more,
because
but
of it?
I think Ms. Miller and I would actually, and ACLU would probably like to talk about this a little more offline. And if I may just ask one more.
One more.
Thank you. The applicant, after going through the process, et cetera, is still, the licensing board is still saying no. Does this allow them to go to take civil action, go to district court to get it resolved, or is it final? Do the licensing boards have final say?
For the record, Atar Hasibullah, ACLU of Nevada. As it stands right now, there's always the ability to challenge agency determinations through a court. What the bill would in fact do would be to shift the burden and the onus over to the board and require specific parameters and standards set forth by the board in terms of the licensure denial. As it stands right now, the onus and the full burden of justifying the actions underway would fall on the applicant. This would shift that over to the board. So the board would have to have established, again, through the evidentiary standards that we'd laid out, the clear and convincing evidence that the denial satisfied the standards of this particular bill.
And I would like to add to that as well, that again, this bill is not at all implying that every single applicant must be granted a license. It's just asking for case-by-case scrutiny as they review each individual case. So again, there still will be licenses denied. It's just their ability to prove for cause why it was denied.
And that's what I just wanted to clarify and make sure I understood it correctly. Thank you, Chair, for the time. I appreciate it. Thanks for the answers. We'll talk some more, all right?
Absolutely.
Thank you.
Thank you.
Assemblywoman Kasama.
Thank you so much for the presentation. When we said the disqualifying offense, they've been found guilty, they've been imprisoned, or were released within the last 3 years from prison. Just curious, is there some precedent for using 3 years? Where did that come from?
For the record, Atar Hasibullah, ACLU of Nevada, that's what the best practices have suggested at the national level. We've looked at a couple things. One of the things we looked at on the front end in conjunction with our partners at Institute for Justice, and I believe the Council for State Governments also submitted a letter of support for this bill, was specifically reducing recidivism rates. And we've recognized that that period of time likely falling outside of that window encapsulates the quickest period of time where we think that the rehabilitative elements as defined by this bill would have been able to be demonstrated and could have came through, but also doesn't preclude somebody from being extended out enough to where it precludes their option for applying for the occupational licensure or otherwise dims their interest in seeking one.
Wonderful, thank you.
Thank you.
Assemblywoman Hardy.
Thank you, Chair, and thank you for this bill. I think a lot of people have heard me say this session, recidivism is something that I'm very interested in, and I think it's, so when I read this bill, I was just really happy to see this, that we can work in that space. And so I just wanted to make sure that, and I appreciate some of the things that were said here, that there's no simple denials, that we're looking at a totality of a circumstance or person, giving somebody the opportunity to, discuss what happened and see their progress, and then giving them that opportunity to rebuild their lives and move forward and contribute to our communities. So I just want to make sure that I'm clear. Are there any situations where a board could just flat out deny it? Or is it all circumstances would go through this, this process as outlined in the bill?
For the record, Atar Hasibullah, Assemblywoman Hardy. So the board could still make a denial of the application, but the process for how the denial must occur has been laid out by this bill. What that would look like is a potentially disqualifying felony offense, as mentioned here. If an individual falls within that provision and the board chooses at that point to deny them, the process for that denial is outlined here. So again, it's not a blanket you can't deny someone. It simply lays out the process for if you're going to deny, and what those provisions for denial end up looking like. They must be followed and spelled out clearly, and no more would agencies simply be empowered to have suggested sort of approaches to those occupational licensing denials. So in effect, it doesn't stop an agency or a licensing board from denying an occupational license. It just makes clear what the process is and lays out specific parameters for what the board can consider in doing so. Thank you.
Committee members, any additional questions? I don't see any. We'll move to support testimony of Assembly Bill 363. Is there anyone here in Carson City wishing to testify in support of Assembly Bill 363? Please state and spell your name for the record. You will each have 2 minutes.
Thank you, Chair. Elliot Mallon for the record with Alpine Strategies. In 2019, then Assemblywoman Jill Tolles worked with me on AB 319. Our speaker was one of our primary sponsors. Assemblywoman Hardy was another sponsor, co-sponsor of that bill. AB 363 today is a natural continuation of that bill. I couldn't be more thrilled to be here in support of this bill. One of the most important things I view that we can do here is helping people get back to work and reduce recidivism. It helps us create better members of society, better members of our community. It reduces the strains on our community as well. It reduces the tax burden that is placed on the state. An interesting statistic I want to highlight really fast to show how important this legislation is. Per NCSL, from a study that I remember seeing in 2019, 1/4 of Americans require a license to work. 1/3 of Americans have a criminal conviction. Nevada was one of the first states to address this problem with AB 319, and I know Speaker Yeager actually spoke at NCSL about that bill. I was very excited about that. Thank you. But this is that continuation, the natural way that we can help others reduce recidivism and get them back in the economy and treat them as full members of our society. So I could not be more thrilled to be here. I really appreciate Assemblywoman Miller bringing this forward, and I urge all of you to support it. Thank you very much.
Thank you, Madam Chair. John Piro from the Clark County Public Defender's Office. This is a common sense piece of legislation that breaks down barriers and provides a pathway to a good job, which is one of the best ways to prevent recidivism. So that's the nexus for me as a public defender. I never want to see my clients again in that capacity. I always want to see them on the road to success. And a good job is one of the best ways to prevent recidivism. This bill is actually less about thinking outside the box and more about providing a pathway to inclusion, rehabilitation, resilience, and redemption. And we strongly urge its passage. Thank you.
Good afternoon, Chair Marzola and members of the committee. My name is Sarah Evans, S-A-R-A-E-V-A-N-S. I'm the Vice President of the Supervisory Unit with SEIU Local 1107. We thank the bill sponsor, Assemblywoman Miller, and the ACLU for bringing this bill forward. SEIU 1107 represents over 18,000 workers, including 8,000 nurses. As you heard, nurses were the largest group affected by the denial of an occupational license based on past criminal history. SEIU supports this bill, and we urge the committee to support this bill. Thank you for your time.
Good afternoon, Chair and members of the committee. For the record, my name is Christine Saunders, and I'm the Policy Director at the Progressive Leadership Alliance of Nevada, here in support of Assembly Bill 363. While Nevada has made some strides over the past few legislative sessions to address occupational licensing reform, there are many steps we can make to improve employment opportunities for Nevadans. AB 363 makes common sense changes to why a licensing board can consider with an applicant and shift the burden to the state to justify the denial. Having a job and being able to afford basic necessities and stable housing are key components to reduce recidivism. Passing AB 363 will benefit not only those who are formerly incarcerated, but their families and the economy as a whole. We urge your support. Thank you.
Paul Catha, that's spelled Catha, with the Culinary Workers Union Local 226. We support Assembly Bill 363 and echo the comments of our colleagues. Thank you.
Thank you for your testimony. Is there anyone else in Carson City wishing to testify in support? I don't see anyone. Broadcast, is there anyone on the line wishing to testify in support of Assembly Bill 363?
If you'd like to testify in support of Assembly Bill 363, please press star 9 now to take your place in the queue.
Thank you, Chairwoman Marzola and members of the committee. My name is Wiz Rizard, Wizrouzard, and I'm the Deputy State Director with Americans for Prosperity. And on behalf of thousands of our grassroots activists, and as the premier grassroots organization dedicated outreach, education, advocacy on long-term solutions to the country's biggest problem, we definitely urge you to support AB 363, which includes effective reforms to our nation's criminal justice system by addressing one of the greatest existing barriers to realizing the American dream. AB 363 is a smart, common sense reform that will provide more opportunities for individuals to participate in the workforce and successfully reintegrate back into society after getting a criminal record. Accountability and personal responsibility are critical components of our justice system. This also means that once someone has fulfilled the debt that they owe to our community, it is essential that we reduce unnecessary barriers for them to become productive citizens in our communities and avoid future criminal behavior. According to the National Reentry Resource Center, Nevada has at least 257 different legal barriers to individuals gaining a license or certificate to work in certain fields. AB 363 wisely allows this licensing board to consider certain criminal history when issuing occupational licensing. This bill simply places common sense conditions around those determinations. And lastly, what I'll say is you are, per our Constitution, you are innocent until proven guilty. Again, I will reaffirm that. We are innocent until proven guilty, and that innocence extends all the way through to your occupation. And I urge the committee members to definitely support AB 363. And thank you to the stakeholders for driving this bill and giving us the opportunity to work along with them. And I encourage any members of the committee, if there are any questions, we're happy to work with you as well, and ensuring that we get to a position where we can have some bipartisan support on this amazing bill. Thank you very much, and you all have a great day.
Thank you for your testimony. Broadcast, is there anyone else on the line?
Stand by, Chair.
Thank you, Chair Marzola and members of the committee. My name is Eric Jeng, ERICJENG, representing One API Nevada, advocating for our fast-growing Asian Pacific Islander community here in the state. I want to thank Assemblywoman Miller for sponsoring this bill and ACLU Director Hasabullah for his presentation on the importance of this bill. As someone that has personally volunteered to translate, outreach, and even troubleshoot for state licensing tests for occupations with high percentage of API community members, such as reflexology and massage therapy, I want to know how much work and effort these aunties and uncles and older sisters and brothers that studies and prep to make sure they acquire and retain their licenses. A denial of license not only means loss of income, but some of our more vulnerable community members means falling into a cycle of exploitation and recidivism. On today, we also want to note it is AANHPI Pay Equity Day. This is the day that how many days that AANHPI women have to catch up to the white counterpart. This bill removes unnecessary barriers, provide wider access for hardworking Nevadans to earn their living and strive for a better life, and will further help our community close the gender and race wage gap. We urge for your support for AB 363. Thank you.
Thank you. Broadcast, is there anyone else on the line?
Madam Chair, thank you for the opportunity to speak in support of AB 363. My name is Megan Forbes, MEAGANFORBES. I'm Senior Legislative Counsel at the Institute for Justice. We are a nonprofit law firm that works to protect economic liberty. We've also studied the burdens of occupational licensing, particularly on lower income workers and people with criminal records. Our research shows that licensing creates significant barriers to entry and disproportionately affects many populations, especially people with criminal records. As has already been stated, the Institute for Justice published a national study of the collateral consequences of licensing restrictions for people with criminal records called Barred from Working. In our report, Nevada was one of only 6 states to earn an F because of its lack of meaningful protections for people with criminal records and licensing. Having a binding predetermination process is important to support successful reentry and to set returning citizens up for success. This is a process 24 states currently have. Licensing laws can have a chilling effect on people with criminal records. Some people may never pursue a license simply because they think their criminal record is disqualifying and they can't afford the risk. A binding predetermination process helps give returning citizens the information they need to make decisions about their careers and their future. And to wrap things up, we think this bill is a very important way the state can safely create opportunities, support businesses, and increase public safety. We thank the committee for considering this legislation. Thank you.
Thank you for your testimony. Broadcast, is there anyone else on the line?
Chair, we have no more callers in support at this time.
Thank you. We'll move to testimony in opposition to Assembly Bill 363. Is there anyone here in Carson City wishing to testify in opposition? Please state and spell your name for the record, and you have 2 minutes each.
Thank you, Chair Marzola and committee members. Misty Grimmer representing the Nevada State Contractors Board. The Nevada State Contractors Board has some concerns with AB 363 and how it could possibly hinder our ability to ensure that the folks that we license are not likely to be any risk to the general public. We license individuals who are granted access to people's homes and families, so we take the consideration of criminal backgrounds very seriously. We have visited with the bill's sponsor and shared our concerns and fully understand the goal she is trying to achieve to make sure professional doors are not automatically shut to people just because of past transgressions. To be very clear, there is no crime that would automatically eliminate a person from being considered for a contractor's license. As has already been mentioned, AB 319, which was passed a few sessions ago, which was a similar bill requiring pre-screening process and a creation of a list of crimes so a person could know that they were automatically be disqualified. The legislature agreed at that time to exclude the Contractors Board from that statute because there simply is no such list. I will provide for the committee a summary of how we address this situation where an applicant has a criminal background. I believe if you compare the process we have in place to what is being recommended in AB 363, you will see that we already do what the goals of this bill are seeking to achieve. The bill does, however, add additional layers that would complicate our process, specifically the reference to disqualifying offenses being only those which have occurred within the last 3 years and for which the individual was incarcerated. If a person has been convicted of a crime against children, for example, or multiple crimes against children, even if it was a decade ago, we may want to consider if we should allow that person to enter homes where children are likely to be present. However, if the license they seek was just for commercial work, perhaps it wouldn't matter. Another concern is the language in sub 4, the potentially disqualifying felony offense directly and specifically relates to the duties and responsibilities of the occupation or profession which the applicant seeks a license. This section creates some ambiguity for us because the trades we license for, such as plumbing or roofing or HVAC repair, it's unlikely a crime would have been related specifically to those. But if that person has a conviction for burglary, for example, we may consider not granting a license that would allow them access to residences or businesses. Additionally, with respect to this section, unlike many other boards who license just the individual performing the work, we actually license the entity. So any history of financial crimes would also be something that we may take a look at. Furthermore, I have a minute, right? Okay. Furthermore, the process outlined in sections 5 through 7 would have the effect of tying the board's hands once an informal hearing with the executive officer has made a decision. It's our current practice to do...
Ms. Grimmer,
Yes,
if you
ma'am.
can wrap it up, please. You're over your 2 minutes.
Oh, I was looking at that and I thought I had more time. Okay. These processes have been developed over many years at the direction of the legislature and through the regulatory process that is also approved through the legislature. For these reasons, we believe that our process already covers the individual, that we individually consider each person's application and will continue to work with the bill sponsor on this bill. Thank you.
Thank you, Madam Chair. Michael Hillerby, Hillerby, on behalf of the Nevada State Board of Pharmacy and State Board of Accountancy. I'll echo many of the colleagues from my comments from my colleague, Ms. Grimmer, with the Contractors Board. The legislature over the years has created some very specific criteria for different boards. For example, in pharmacy and accountancy, much as with contractors and other boards, there is no offense for which there is an automatic disqualification. The board may consider anything, and in those statutes in particular and others, there are a specific list of things that we can consider that are related specifically to the job duties. So I also want to thank Assemblywoman Miller for meeting with Ms. Grimmer and I on Friday. We certainly support the goals of the bill. We agree that the process ought to be as uniform and as simple as it can be. We want it to be friendly, want to help people get back into the workforce where that's appropriate. Again, where you've got statutes that the legislature has created over the years with very specific criteria already laid out, and I understand it's a skeleton bill, the overarching language that would supersede all of that we think is problematic. So for those boards that have already have those criteria in place and are doing that, would want to take that into consideration as well. And I do agree with the comments Mr. O'Neill made and the other witnesses, probably clarifying in the application that an arrest with pending charges rather than just any arrest history. So I think there's certainly some things we can do better. We should never be afraid to ask those questions. But again, as others have said, the ability to get good information that's directly tied to protecting the public health and safety within that occupation remains important, and we'll be happy to work with the committee and the sponsor, and again, appreciate her meeting with us. Thank you.
Madam Chair, members of the committee, for the record, my name is Nina Laxalt, and I represent the Nevada Board of Veterinary Medicine, the Psychology Board, and the PT Board, and I will be speaking today specifically on behalf of the Veterinarian Board. We too, excuse me, agree with the goals that this bill is trying to reach. However, we have a little bit of differences, as all boards do. It's not one brush, across the board. Veterinarian denials and usually animal crimes are typically not felony crimes. So any animal abuse crimes are under that, so they would not meet that criteria. So clearly, when you're looking at a veterinary license, if an animal abuser has not done a felony, I couldn't think of the word, done a felony for any other purpose, an animal abuse would not meet the goal of a felony. So we would never find those people if they were getting into the veterinary business. The second thing is we believe that under this bill, that the contested cases could go under judicial review, and our other denials don't usually have that option, so this would carve that out specifically for judicial review. We do have some suggestions that we can provide to the sponsor and work with them, work with her on our concerns and maybe how this could work as far as the process goes for the boards.
Thank you, Madam Chair. Committee, for the record, Susan Fisher with McDonald-Carano, speaking today on behalf of the Nevada State Board of Professional Engineers and Land Surveyors and also the Nevada Osteopathic Medicine Board. Same reasons that you've already heard here. We would like to talk with the bill sponsor, but we do take in the individual cases, and I've sat in on some of the disciplinary hearings or the licensing hearings where a person has had some sort of a criminal background before, and the boards have been very thoughtful in their processes and in looking at it. If it had been a drug offense and the person has gone through counseling and continuing counseling, they are very thoughtful in that process. And we do realize when you've done the time, you do the crime, you do the time, and you shouldn't suffer for it the rest of your life. But we do need to have some precautions in place. Osteopathic doctors do have DEA licenses, and also with professional engineers and land surveyors, they're often going into someone's backyard, so we need to be able to peel back the layers of the onion and find out what the crimes were in the past. Thank you.
Thank you for your testimony. Is there anyone else wishing to testify in opposition to Assembly Bill 363? I don't see any. Broadcast, is there anyone on the line wishing to testify in opposition?
If you'd like to testify in opposition to Assembly Bill 363, please press star 9 now to take your place in the queue.
Good afternoon. I'm actually offering my support for the bill. My name is Alejandro Ortiz, O-R-T-I-Z. I'm a senior staff attorney with the Racial Justice Program of the National Office of the ACLU. In my view, and the ACLU's view, supporting this should be easy. First, it's good for the economy. As Governor Lombardo recently announced, Nevada has 1.7 job openings for every unemployed person looking for work, and there are acute shortages of employees in core sectors of the economy. Many would-be workers are standing on the sidelines, deterred from even seeking a job because of their criminal record. Nevada should make easier, not harder, for people willing to work to obtain jobs. Second, it's good for public safety. Studies show that successful entry into the labor force greatly decreases recidivism. This makes sense. If people with criminal records are unable or limited in their opportunities to obtain lawful employment, then resorting to unlawful means to support oneself becomes a viable option. Finally, doing so promotes racial justice and faith in our criminal legal system. Black people are 6 times more likely to be incarcerated than white people, and Hispanics are about 3 times more likely to be incarcerated than white people. When the government discriminates against people because of their criminal records, it hurts everyone with a criminal record, but it particularly hurts communities of color. Moreover, people who've paid their debt to society by fulfilling their sentence should be allowed to work. Doing so gives meaning to the value of redemption underlying our criminal legal system. In some instances, however, licensing boards in Nevada deny licenses to people charged but never convicted of a crime. I've seen this personally. This is a gross injustice. It turns a fundamental pillar of our criminal legal system on its head, that people accused of crimes are presumed innocent unless they're proven guilty. As you consider this bill, ask yourself, should a person be punished for a crime for which they were not convicted? In summary, this bill is good for the economy and public safety and promotes fairness and racial justice. For all these reasons, we at the ACLU office, the National Office of the ACLU, urge you to support the bill. Thank you for your time and consideration.
Thank you for your testimony, and we are in opposition, but I will be moving your testimony to support. Thank you. Broadcast, is there anyone on the line in opposition to Assembly Bill 363?
Chair, we have no more callers in opposition at this time.
Thank you. We will move to testimony in the neutral position. Is there anyone here in Carson City wishing to testify in neutral to Assembly Bill 363? I don't see anyone. Broadcast, is there anyone on the line wishing to testify in the neutral position?
If you'd like to testify in neutral for Assembly Bill AB 363, please press star 9 now to take your place in the queue.
Good afternoon, Madam Chair. J.D. Decker. I'm the Administrator of the Compliance Enforcement Division for the Department of Motor Vehicles. The Compliance Enforcement Division issues professional or occupational licenses for auto dealers, auto salespersons, garages, body shops, emissions inspectors and stations, drive school instructors and operators, and auto wreckers. I have a couple items that I might bring to the committee's attention. In our last communication from our Department of Public Safety in Nevada regarding the petition that was authorized in AB 319 in 2021, it was found to violate DOJ's federal regulations for access to criminal history and was not being processed. The second item that I'd like to bring to the committee's attention is that Section 3 Sub 2 seems to allow the applicant to determine whether or not a felony should be disclosed by deciding for themselves whether it is relevant to the license application. And then the last item, Section 5 and 7 of the bill would require department leadership to meet with license denied applicants in an appeal-type meeting in which the applicant could present witnesses and evidence of suitability and appeal the director's decision to a regulatory body. This bypasses or duplicates the existing appeals process through the Department of Motor Vehicles Hearings Division that exists in NRS 482.353, 47.160, NRS 233B, and NAC 445B.464. Thank you.
Thank you for your testimony. Broadcast, is there anyone else on the line?
Chair, there are no more callers in neutral at this time.
Thank you. Assemblywoman, would you like to give any final remarks? You can begin when you're ready.
For the record, Atar Hasibullah, Executive Director for the ACLU of Nevada. Assemblywoman Miller asked that I go first instead of second. But today you've heard a presentation on a very important piece of legislation that can help get Nevadans back to work. As Assemblyman O'Neill pointed out, there's a couple minor issues that we're happy to work through in terms of what flexibility might look like here, in terms of making sure that we have a bill that's crafted for the betterment of Nevada. You've also heard opposition testimony that wouldn't put people back to work. And at the end of the day, we'd be back here 2 years from now, still saying we have an F. We might end up with an F minus or an F plus, but we'd be in the same F category because nothing's changed. So we'd urge this body to support this bill, move forward with it, help create occupational licensing reform as necessary, mandate that the burden shift from the individuals who are being denied licenses to these strong agencies that have the ability to oversee someone's future, and pass this bill. And we also urge you to consider doing more occupational licensing reform work as time progresses, because this is one of the areas that we at the ACLU feel will help unify the state, bring the state together, and get more people in a better position for themselves and for their families. So with that, we thank you for your time.
Thank you. This is Assemblywoman Brittany Miller for the record. And again, I just want to thank the, and attest to the fact that, yes, those that came forward in opposition, thank you. It's hard for me to say, but for those who came forward in opposition, we did meet, and I am encouraged by the fact that even walking out, generally people in opposition don't stop you to tell you what they, how willing they are to work with you. And again, when we met, it was about adjusting some of those technicalities to make sure that this is something that works for everyone in every regard. And what was the most encouraging is that from those that I did meet with, that again, they do support the sentiment and the goal, as you heard them state on the record as well. So that was very encouraging for me in the direction that we as Nevadans are trying to go. So I thank everyone for your attention and the opportunity to present this bill, and I urge your support. Thank you so much.
Thank you for your presentation today. I will now close the hearing on Assembly Bill 363. I will now open a hearing on Assembly Bill 364, which revises provisions governing physician's assistants. Assemblywoman Cohen, you may begin when you're ready.
Thank you, Chair Marzola and members of the committee. For the record, I'm Leslie Cohen, representing Assembly District 29, and I'm presenting Assembly Bill 364, which revises provisions relating to physician's assistants. So for some background information, Nevada, like states across the country, is grappling with a healthcare provider shortage. Healthcare providers in Nevada are retiring, especially in the family practice and primary care worlds, physician assistants help fill this void in our healthcare system. Physician assistants are advanced practice allied health professionals who are nationally certified and licensed in Nevada through the Board of Medical Examiners and State Board of Osteopathic Medicine. Before they can earn licensure, PAs undergo rigorous education and training as medical professionals. In Nevada, a PA must enter into an agreement with a physician in order to practice. Assembly Bill 364 would allow, among other provisions, PAs to practice without a supervision agreement with a physician, osteopathic physician, or a group of physicians or osteopathic physicians. The intent of this measure is to remove the administrative burden for PAs and physicians and increase access to care for our citizens. The measure allows PAs to practice where they are needed most, such as our rural areas where a PA may be the only available healthcare provider. Assembly Bill 364 does not allow physician assistants to expand their scope of practice unless they receive extra training or licensure requirements. So before I do a walkthrough of the bill, I'd like to introduce a couple of physician's assistants who have come to give us some information and talk to the committee, and I really want to turn the hearing over to them because they're the ones who really know the situation and what's going on with healthcare. So first we have Carmela Downing, who is a PA at Carson Tahoe Health and has worked in cardiology for 15 years. She manages the Congestive Heart Failure Clinic and is the Advanced Practice Medical Director for Carson Tahoe Medical Group. And then we also have Ben Prohaska, who is currently practicing endocrinology in Reno and has been practicing as a PA in Nevada since 2005. He's the immediate past president of the Nevada Academy of PAs. Mr. Prohaska is a board member of the Nevada Diabetes Association, and he also serves as one of the medical providers at a week-long diabetes camp for kids each summer in Lake Tahoe. So with that, with your permission, I'd like to turn the microphone over to them.
My name is Ben Prohaska, Prohaska for the record. Good afternoon, Chair Marzola and Honorable Committee. I've been a PA in Reno for over 17 years, and I am here as a board member and as the immediate past president of the Nevada Academy of PAs, referred as NAPA, to express support of Assembly Bill 364. NAPA aims to improve access to quality health care in the state of Nevada and gives a voice to the PA profession through education and advocacy. With over 1,300 PAs working in every facet of Nevada state's healthcare industry, we are committed to delivering high-quality healthcare to all Nevadans. Today, we'll discuss 3 points: education, background, and qualifications of PAs. Number 2, the benefits of removing physician supervision of PAs. And number 3, adding PAs to the regulatory boards, such as the Nevada Board of Medical Examiners. I first turn to the education background and qualifications of PAs. Admission to PA school is highly competitive at the UNR PA program with an acceptance rate of just 1.4%. The average applicant brings with them over 6,000 hours of paid healthcare experience before entering the program. Before I went to PA school, I worked at St. Rose Hospital in Henderson in the Cardiology Center and Cardiac Cath Lab for 5 years in the 1990s while I went to UNLV for my undergraduate degree. The average age of a student admitted to PA school is 28. Students undergo training at the graduate level to include 123 credit hours, which includes the classroom and over 2,000 plus hours of clinical hours doing rotations in multiple specialties, such as the emergency room, surgery, family practice, cardiology, endocrinology, and gynecology. We are trained in the same medical model as physicians. We must then pass a national certification exam to gain board certification. To maintain our license with the Board of Medical Examiners here in Nevada, like all physicians, we must complete over 40 hours of continuing medical education credits every 2 years. On top of that, however, to maintain our national board certification, we must complete 100 hours of continuing medical education every 2 years and pass an exam every 10 years. PAs are medical providers who can diagnose and treat illnesses, prescribe medications, and we can do much more. For example, I hold my own Nevada State medical license, I have my own DEA license, and I have my own Nevada State Board of Pharmacy license. Thus, Nevada PAs are qualified. Next, I address the bulk of this bill, removing physician supervision of PAs. I'm confident you are all aware that Nevada is at the bottom or close to it on multiple healthcare measures, namely access to healthcare services. The issue is worsening, and PAs are here to help address this trend and turn it around for good. Removing supervision sections 5, 10 through 12, 24, and 26 through 29, research indicates that the most up-to-date practice laws allow healthcare teams to decide at the practice level how they will be best collaborative to meet patients' needs. The best evidence supports that the most successful clinical teams are those that fully utilize the skills and abilities of each team member and support efficient patient-centered healthcare. The key word here is team for us. PAs, like physicians, are most often employed by hospitals, medical groups, and other facilities. These facilities, which are located in Section 4 and 23, address where PAs are authorized to practice, have supervision oversight requirements for all employees to ensure patient safety and mitigate liability. Assembly Bill 364 removes supervisory language from the Nevada PA Practice Act, allowing clinics and hospitals greater flexibility in assembling healthcare teams to meet patient care needs. The more collaborative and interdependent practice arrangement has either been enacted or is currently being considered in several other states and has provided greater agility in meeting healthcare needs in those rural areas. It is not surprising, but perhaps less known, that several branches of the federal government, including the military, the VA system, and IHS, which is Indian Health Services, have long ago removed physician supervisory requirements for PAs and recognize their ability to practice autonomously and safely in thousands of different practice settings and assignments at home and abroad. Additionally, it is also worth noting that removing unnecessary supervisory requirements in Nevada also benefits physicians. These benefits include removing physician liability for the care of PA provides when the physician is not involved, thereby reducing physician and employer risk of disciplinary action for administrative reasons. For example, I work in a practice with a physician and I see my own patients every day. That's where I was this morning. And my physician was not there in the building. If I were to make a mistake with a patient, current law dictates that my supervising physician would also be held liable for my decision-making. Yet, they may have never met the patient before, and furthermore, may have not even been working in the practice that day. Nevada PAs greatly respect the breadth and depth of our physicians' training, and are proud to practice medicine alongside them every day. Our practices and patients benefit from this team-based approach. We are not looking to be physicians. We are not looking to do surgery on our own. It continues to be the position of NAPA that physicians are essential to our healthcare team. We stand by the historic relationship and devotion to team practice with physicians and all members of the healthcare team. However, team-based care is the best patient-centered care delivery method which creates access to healthcare, even in the most rural areas of Nevada. Furthermore, with the modernization of PA practice laws in neighboring states such as Utah and other Western regional states and across the country, we are at risk of driving our PA students outside of Nevada upon completion of PA programs. Nevada has experienced this with other health professions. Let's not repeat it with PAs. Providing favorable, safe PA practice laws will allow Nevada to keep our most valuable resources, our newly graduated PAs. Passing this bill would allow us to retain our PAs, take care of our PAs here in our state, and to attract PAs from out of state. It's kind of a novel concept of getting healthcare providers to want to move to Nevada to work. Finally, this bill proposes that PAs be added to regulatory boards. This bill gives PAs a meaningful input into the regulation of the PA profession. This bill allows PAs to be an expert voice on current knowledge of the profession when regulatory boards make decisions affecting its licensees like myself. In a rapidly growing field, we believe that adding a PA to regulatory bodies is essential to ensuring that PAs are able to contribute to increasing healthcare access and quality. I want to conclude my remarks by thanking the sponsors, Assemblywoman Cohen and Assemblyman O'Neill, and several other co-sponsors for bringing this bipartisan legislation forward and continuing their work to progress the healthcare system in the state of Nevada. This legislative body 6 years ago found the wisdom to progress nurse practitioner state laws. The physicians groups opposed this at that time, yet this body still passed those bills. This current bill proposes to bring PA laws in conjunction with that of Nevada state nurse practitioner laws. I respectfully ask that this committee pass this bill. Thank you for your time and consideration.
I'd like to thank Madam Chair and the committee for this opportunity today, and also Assemblywoman Leslie Cohen and Assemblyman P.K. O'Neill for their support. My name is Carmela Downing, D-O-W-N-I-N-G. I'm a physician assistant working here in Carson City, and I'm a representative of the Nevada Academy of PAs Legislative Committee. I'll be referring to physician assistants as PAs for the remainder of my discussion. AB 364 is about transparency of current practice within healthcare teams, modernization of outdated language regarding the supervisory relationship between a physician and a PA, and the representation of PAs by the medical board which govern them. I wholeheartedly support AB 364 because I know that in doing so will increase the PA workforce throughout the state, reduce health accessibility gap, and remove physician liabilities for PAs, decrease patient morbidity and mortality by facilitating timely health care, and reducing healthcare spending related to unnecessary emergency room department visits. My own practice is an example of this. I help design and now manage the congestive heart failure clinic at Carson Tahoe Health. My clinic gives follow-up visits after education in the hospital within 7 days of discharge, and most patients are seen weekly the first week out of the hospital. The current national average readmission rate within 30 days for heart failure patients is 23%. Since the initiation of the congestive heart failure clinic at Carson Tahoe Health, we average 11% readmission. We have decreased ER visits, costly, unnecessary hospital admissions with a program managed by a PA. I want to make it very clear that AB 364 does not signify independent practice by PAs, change of education or certification standards, nor hasten PAs to open a private practice. The collaborative relationship of a PA with a physician and other providers will not change. As the Advanced Practice Medical Director, I work with physicians, PAs, nurse practitioners, and management to create appropriate collaborative agreements and onboarding plans for our new hires. AB 364 will not change this. What it will change is how healthcare employers meet the healthcare needs of the state. Nevada is experiencing a healthcare crisis. As Ben explained, healthcare access in our state is among the nation's worst. Our statistics are dismal. We aren't trying to reinvent the wheel, we are trying to not fall behind. But let me give you some more real examples from here in Carson City. When I first started on our recruitment committee, we reviewed candidates for an urgent care position. A nurse practitioner with just over 4,000 hours or 2 years clinical experience was favored over a PA with over 5 years experience due to a lack of available supervising physician to sign a supervision agreement. After 4,000 hours, nurse practitioners can practice independently. Nevada does not have enough providers, particularly physicians, to keep up with the demands of the metropolitan areas. We are neglecting our rural and frontier areas due to burdensome administrative complaints. Fortunately, our neighboring states have implemented an environment where PAs may practice to the full extent of their medical education, training, and experience. Additionally, Nevada is the only Western state that does not allow a PA representation on the medical boards that oversee them. The PA Advisory Board, created for the Nevada State Board of Medical Examiners, does not allow a PA to vote on any professional matters. Nevada has suboptimal PA practice landscape. Utah and Arizona have passed similar legislation that is found in AB 364. Additionally, Montana's bill passed the Senate last week. How do we expect to address Nevada's issues regarding access to health care without modernizing the regulations that stagnates PA's ability to care for our patients? Nevada has fallen behind, and we will continue to do so if this legislation is not passed. I appreciate your time today and humbly ask for your support in AB 364.
Leslie Cohen, Assembly District 29. Would you like me to do a quick walkthrough of the bill? Okay. So sections 1 through 3, 13 through 16, 18 through 20, 22, 25, 32 through 34, 37 through 80, 85 through 89, 91 through 97, 97 through 127, 129 through 167, and 170 through 201 make various changes so that the physician assistants have similar authority and duties to other providers of health care who provide medical service independently and are otherwise treated in the same manner as other such providers of health care. Sections 4 and 23 require a physician assistant who has practiced for less than 4,000 hours as a physician assistant to enter into a collaborative agreement with a physician and prescribes the setting in which a physician assistant is authorized to practice, a medical facility, any facility licensed pursuant to Chapter 440 of NRS, or any facility that has established a system for evaluating the credentials of and granting practice privileges to physician assistants, a facility or medical practice owned by a physician or osteopathic physician or group of physicians or osteopathic physicians, a federally qualified health center, or a correctional facility or institution, a state, county, or district health department, or any other location authorized by the board. Sections 6, 7, 8, and 202 require the appointment of 2 additional members of the Board of Medical Examiners who are physician assistants. The board is authorized to select physician assistants to serve as advisory members of the board. Sections 5, 10, 11, 12, 24, and 26 through 29 remove the requirement that a physician assistant be supervised by a physician or osteopathic physician. Sections 9, 21, 30 through 32, 33, 35, 81 through 84, 90, 98, 168, 169, and 204 remove references to the supervision of a physician assistant by a physician or osteopathic physician. Section 10 and 26 require a physician assistant to obtain the informed consent of a patient before providing any medical service, prescribe medical services that a physician assistant is authorized to perform, and require a physician assistant to only perform such services within his or her scope of practice in which he or she has the necessary education, training, and experience to competently perform. Sections 12 and 28 remove a requirement that the Board of Medical Examiners and the State Board of Osteopathic Medicine adopt regulations governing the testing or examination of applicants for licensure as a physician assistant and the services which a physician assistant may perform. Sections 17 and 32 authorize an unlicensed person who meets the requirements for licensure as a physician assistant to refer to himself or herself as an inactive physician assistant. Section 30 makes technical revisions concerning the renewal of a license of an osteopathic physician assistant. Section 36 removes a requirement that the State Board of Pharmacy consider the experience and training of the physician assistant when adopting regulations governing the administration, possession, dispensing, storage, security, record-keeping, and transportation of controlled substances, dangerous drugs, poisons, and devices by a physician assistant. Sections 54, 56, 70, 126, 142, and 178 add advanced practice registered nurses to certain provisions so that physician assistants and advanced practice registered nurses have similar authority. And Sections 128 removes the requirement that a rural clinic where medical services are provided by a physician assistant or advanced practice registered nurse be supervised by a physician. And then, if I may, in closing, Chair, I do have a letter that we did provide to the committee as an exhibit. It's from a physician assistant from one of our not just rural but frontier communities that she'd asked that I read And if it would be possible, if I could read it to the committee, because I think it's very impactful and explains a lot about the importance of this bill. Okay, thank you. So it starts, my name is Ann Hines Miles, and I'm a physician assistant. I graduated from UNR with distinction and received my physician assistant training through Western University of Health Sciences at University of California, Chico. I have been a rural practitioner for 20 years, of which 11 of them have been in the frontier. I am instrumental in the creation of the Kingston Health Center. The rural area designation for healthcare is most of the towns in Nevada, excluding Reno and Las Vegas. Rural areas are Elko, Ely, Dayton, Yerington, Tonopah, and other like cities. They have pharmacy, paved roads, cell service, hospitals, EMT, ambulance service, and urgent cares. They have stores for bandages and assorted treatments. They usually lack medical specialists or specialties. Frontier towns are totally different, as they seldom have any of the above-mentioned services. These towns include Round Mountain, Rachel, Austin, Luning, Midas, Jarbidge, and Kingston, to name just a few. It is not unusual to travel 100 miles for a pharmacy or hospital. This doesn't mean they don't deserve readily accessible health care. There were many challenges I had to accept when choosing to practice in the rurals and the frontier. Professional isolation and lack of support is only one aspect. Over the years, I was able to create a team of specialists who would always take my call or text when I had a question. All medical professionals have colleagues they rely on for support and answers. Having an assigned physician, collaborator, supervisor can be difficult, as many doctors are unwilling to stretch their liability 100 to 200 miles away to cover a PA they hardly know. Who would blame them? Where do people in these communities go if there is an emergency? Is there cell service to call for help? Often not. I fought to keep the clinic open for 5 years. You would think, after all you hear about the need for rural medical care, that it would be irresponsible to not support someone who is willing to give their time and life to serve a remote frontier community. Eventually, my supervising physician retired, and the owner of the RHC clinic closed it, despite outrage from the community. If AB 364 had passed before I retired, I would have been able to continue the operation of the clinic within my scope of practice. Working as a frontier PA is my calling. It takes many years of varied training to achieve the necessary skills to operate in a frontier environment. We are usually the sole provider of any given day. It is important to be able to practice to my full potential. I believe all medical providers begin their journey with altruistic intent, but they soon learn the reality of medicine. Nevada was once the leader in addressing rural healthcare shortages with progressive laws promoting and encouraging PAs. I want to believe Nevada can once again become the leader in progressive healthcare and support the PA profession. Again, this is Ann Miles, previously of the Kingston Clinic in Kingston, Nevada. So with that, we are ready for questions.
Thank you, Assemblywoman, and thank you for your presentation. Okay. Committee members, any questions? Assemblywoman Backus.
Thank you so much for your presentation. And when I looked at this, I missed something. And so it was good when you went through the bill and raised something that stood out to me. Why is it that, and it's in two sections, I think you said section 12 and 28. I guess it pertains to the two different boards, but specifically the elimination of the test or examination of applicants required by the board. Why is that being eliminated in this bill?
So the test historically is very small. It's about 20 questions. It's just testing on whether we have read the laws governing physician assistants.
Can you state your name for the record, please?
My name is Ben Prohaska. So if we remove the test requires us that we have read the laws, the PAs, and that we understand what the supervising physician means. If we remove the supervising physician, we no longer need the test.
Assemblywoman Kasama.
Thank you, Chair. Thank you for the presentation. My question is, it sounds like one of the focus is certainly expanding out in the rural communities. My concern is, Are we developing two tiers of healthcare, one for rural versus the urban, with just the expansion of physician assistants operating independently there?
Again, this is Ben Prohaska. I think bottom line, it comes to, it's not just rural. Like I work in a medical practice. I had, just actually sitting back here, I had 2 patients text me. One is a Sparks police officer, one is actually a physician. They were changing pharmacies and they wanted me to refill their insulin. If my physician I work for were to die in a car accident right now, right this minute, I can no longer refill their insulin because I no longer have a supervising physician. Yet my knowledge is the same as it was 5 minutes ago, or yesterday when I was seeing patients, or this morning when I was seeing patients. I couldn't see my patients tomorrow if my supervising physician is no longer around. That would leave we have roughly 5,000 patients in our practice. That would leave 5,000 patients without either medical provider. So this would remedy that. This would make it so that a PA can practice without a supervising physician, as long as that physician assistant has had enough hours within that specialty to continue to practice, while we then figure out what happens with the practice.
I have a couple questions, but I'll go to Assemblyman Yurek first, and then Assemblyman O'Neill, and then I'll ask my questions.
Thank you, Chair, and thank you both for earlier coming and speaking with me and kind of presenting this idea, because it was definitely kind of shocked my conscience a little bit of this idea of PAs, because I will tell you that I have personally experienced some PAs that are absolutely amazing, some doctors that I would never go back to. And so I don't want to be offensive when I ask this question, but I do think that as far as the ability for PAs to act independently, I think that there is an association or correlation with the level and the amount of training that does occur. So, and please correct me if I'm wrong, but as I understand very generically, a medical doctor to act as an independent provider would have to complete 4 years of undergrad, typically 4 years of medical school, and then anywhere from 3 to 7 years of some sort of residency or fellowship. So there's extensive training. I'm trying to understand how much training, and forgive my ignorance. As I understand it, for a PA, it's roughly 4 years of undergrad, about 2 years of postgraduate PA training, so kind of master's level. And I don't mean that offensive at all, please. And as I look at this, it sounds like the intent is for a PA to be able to operate as an independent medical provider, not under the supervision, but under a collaborative agreement of 4,000 hours. First, I guess my question is, can you help me understand what a collaborative agreement actually means? Because it's obviously different than supervision. I don't know if that's training or what that level of collaboration is. And then in terms of the number of hours, is that a direct correlation? Because I know, for example, a full-time job's about a little over 2,000 hours. So does 4,000 hours equate to roughly 2 more years of collaboration? Can you help me understand those questions?
Carmela Downing for the record. Thank you very much for that question, and I would like to clarify that. I hope I get all of your points in there. I'd like to start with the difference between supervision and collaboration. Supervision, as it is currently by law, is a signature with the state and a box being checked. It does not specify what kind of training, education is provided for that PA once they start, what kind of oversight they see, who they work with. It specifies nothing. What we're trying to do is move the collaboration to the practice level because there are so many different levels of collaboration. For instance, a surgical PA works side by side, day in and day out with their surgeon. Occasionally they see patients in the clinic, maybe on different days, but are very close. Ben and I practice more autonomously. We have a clinic, we see our patients, but we never practice independently. And I would even venture to say that no medical provider practices independently because not even a physician could be able to handle the scope and knowledge in medicine today. Medicine is huge. We all rely on each other. So at the practice level, this is what I do at work at Carson Tahoe. And we design a collaboration agreement. I have a form that I made. We'd go over this with any new applicant of how much collaboration is going to be, whether it's reading journals, completing CMEs, certified medical education, taking extra tests that we have designed. I'm thinking of a current one that I've designed just this week. And additional chart review. We may do more chart review depending on the needs of the PA. The difference might be if I hired Ben to work at Carson Tahoe, we would have a very limited collaboration agreement. He would have a physician to work with. Carson Tahoe has been excellent at really working for optimal team practice. Team is the key word. We work together. A PA or a nurse practitioner is hired to work with a physician in a team-based approach. We want to move the collaboration to the practice level to where it is appropriate for that practice, instead of supervision, which is a signature and a box checked. I hope I answered all of your questions.
Assemblyman O'Neill.
Thank you, Chair. I'm not sure where to start. You've answered several of my questions already, so I think you were wise in setting me up for last. There will be a question, but I've got to say, anybody that says Nevada does not have a need for medical providers to any level, it does never been in Nevada. And that's whether you're here in Carson City or if you're in Eureka, or the letter itself almost speaks words more than what you said on page 292 or 192, whatever it is, of this thick bill. We need medical providers. I know here in Carson myself, I have a choice when I go to see one of my specialists of seeing him or her and making an appointment 3+ months out, or I can see the PA within 2 weeks usually or less. The PAs have always been excellent in their care of me and their knowledge, and the doctors are comfortable with them. Every physician that I know that's worked with the PA relies on that PA. The statistics that Ms. Downing that you gave speak for itself. When we're at 11%, besides that Carson Tahoe, may I say, is an excellent hospital, but it's an excellent hospital because of you and the rest of the staff that work there. And I'll say the same thing for Reno. Wish they were as good as Carson Tahoe, but we'll talk about that later. But seriously, you answered the question about the need. If your physician passed away, that relationship, those patients are all of a sudden left in the lurch, correct?
This is Ben Prohaska? Correct.
Your relationship with physicians, even physicians today do not work independently. If a patient came in, and I know you can't speak for a doctor per se, but with your experience, whether as a PA or working with and seeing physicians, have you ever seen a physician where a patient came in with unusual complaints presenting themselves, not go and ask another physician their thoughts or needs on what this patient may have, just as you do too, or you would if you were out in rural Nevada or even here at Carson? Would you work collaboratively? Do you see that regularly? That's a head shake of yes by Ms. Downing. That's enough. You answered the question. So my last question that I have, our needs are immense. The APRNs have been out there working. We haven't had the situations. We haven't had situations, there's always one or two mix-ups, wherever it may be in any profession. But the needs, I get back to the letter. I want to thank you for bringing this forward and allowing me to sign on to it. It's important for Nevada. And as one of my cohorts said the other night, now is the time to do what is right, and this is what is right. And would you agree with that? And I thank you for the time.
If I can just jump in, Leslie Cohen, Assembly District 29. When you mention Minority Leader, our needs, Mr. Prohaska mentioned our surrounding states, and I was shocked when I heard it about physicians' assistants. It's not just, and Mr. Prohaska mentioned the physicians' assistants that are being trained here and then can move to other states and have, do more in their practice, but they can actually still live here. We have people who can practice in other states and still live in Nevada. We're losing out on having that education and that skill in our state, because what they can do in other states, they know what they can do in other states and how they can put that skill and education to work, and how we're not letting them do that and practice to their potential here the way they can do that in other states.
Thank you for that answer. Committee members, any additional questions? I just have a couple. It's probably more for my understanding. So you're asking to be removed from supervision, but not asking to practice independently. Do I have that correct? Okay. Do PAs right now have DEA numbers?
This is Ben Prohaska. I do. I have my own DEA license, State Board of Pharmacy, and Nevada State Medical license.
So,
and this is not my supervising physician's DEA license. It is a national number. We have our own NPI numbers. We have our PAs have their own number for everything.
So right now you're able to, for example, prescribe controlled substance?
I am able to prescribe any controlled substance, yes. Okay. However, I can't prescribe diabetic shoes.
Okay. I won't go there. Diabetic shoes. Okay. So right now when you see a patient, whether your doctor is there or not, the liability portion is still with the hospital or the doctor that you're working under, correct?
This is Ben Prohaska. Correct.
Okay.
So state law is the physician only has to be in clinic with me 1/2 day a month.
Okay.
So I can work by myself the other 29.5 days. They only have to be reached by phone. They can be in Florida. They can be in New York. And every patient I see, if they're not there, they are still liable if me as the physician assistant were to make a mistake. And that's not really fair. I'm the provider. I should be held liable if I were to make a mistake.
So you actually went to my next question. So removing the supervision portion, the hospital or the doctor would no longer be liable. So does that mean that you would then have your own liability insurance?
This is Ben Prohaska. I have my own liability insurance under, the physician has theirs, I have mine. It's a group liability insurance. I think a hospital, that's a bigger question for probably an attorney. A hospital will probably still be held liable no matter what, right? People like to sue whoever has the money. But myself, and I'm really speaking more at the Board of Medical Examiners, I'm the one held liable at the Board of Medical Examiners. I think a person, if they're hurt, they're going to sue everyone involved. But the physician's license will be safe from mine because we won't be tied any longer at the Board of Medical Examiners.
Yeah, and my question was more, and thank you for that answer. I just wanted to make sure that if we did remove the supervision, right, that God forbid something happened to a patient, there was still a recourse for them. So I appreciate that. Thank you. Committee members, any additional questions? I don't see any. We will move to testimony in support of Assembly Bill 364. Is there anyone here in Carson City wishing to testify in support? Please state and spell your name for the record, and you may begin when you're ready, and you have 2 minutes.
Thank you, Chair Marzola and committee members. My name is John Kenny Larson, John Larsen. I'm a practicing PA right here at Carson Tahoe, and I've been doing this for the past 4 years. I treat extremely underserved population of patients that have chronic lung disease, and I'm in full support of Bill AB 364. I earned a bachelor's degree in respiratory therapy prior to earning a master's in PA studies from Eastern Virginia Medical School. For almost 20 years, I've worked with patients with lung disease, and given my extensive training in pulmonary medicine, I'd like to add to this record that smoking can kill you. Also, bacon can kill you, but smoking bacon will cure it. Now that we have that out of the way, I'd like to say how much it means to me that the PA profession combines all of my training and allows me to practice with all of that knowledge. In speaking to education for PAs, let me just give you a rundown. Average credit hours for PAs in the state of Nevada is 126 hours. Average clinical hours is 2,000 plus. For nurse practitioner schools in Nevada, average credit hours are 51. Average clinical hours are 695. For average credit hours for medical doctors and DOs in Nevada, 178, and average clinical hours, 3,350. So when comparing physician assistants with nurse practitioners and doctors, the benefit for PA schools is there's a strong focus on collaboration. In fact, that's how the profession was started, focusing on collaboration. And so at that time, supervision was not problematic to the profession. However, healthcare has changed. Patient demographics have changed. Access to healthcare has changed. And it's deficient, especially in the state of Nevada. In closing, let me just say, nurse practitioners and PAs are considered equals as providers. Nurse practitioners originally had supervision mandates, but the profession has evolved along with legislation that governs it. PAs and nurse practitioners are considered equals as providers, but are not legislated equally. Luckily for me, I have a supervising physician, but if that supervising physician is no longer here, the chronic lung disease patients that I treat no longer have a provider.
Mr. Larson, if you can wrap it up, please. Thank you.
So I just encourage this legislative body to support AB 364, which will remove unnecessary barriers to providers trained in a collaborative model of healthcare. Thank you.
All right. Thank you, Chair Marzola and members of the committee. My name is Matthew Wilkie, M-A-T-T-H-E-W, W-I-L-K-I-E for the record. I'm here in support of Assembly Bill 364, making changes related to physician's assistants. I want to thank Assemblywoman Cohen for bringing this bill forward. As a healthcare worker myself, I work in a local retail pharmacy right down the road from here. I hear from my patients every week about how hard it is to see any provider for that matter, and I believe that this would that these changes would help provide a positive impact in healthcare for the state. Expanding the membership to the board to include physician's assistants would bring much needed diversity and perspective to the board's decision-making process. Physician's assistants are an integral part and have a unique insight and experiences that affect their profession. Authorizing physician's assistants to perform services without direct supervision under a physician is a step in the right direction. These changes will increase access to healthcare in underserved areas where we all know there is a drastic shortage of all healthcare professionals. It will allow them to practice their full extent of their training, education, and will provide more timely and efficient care for all patients. Eliminating the provisions with testing will streamline licensure processes. The change will reduce unnecessary barriers into entry into the profession and will allow them to practice more quickly. Removing the requirement that a rural clinic be supervised by the physician will also increase access to healthcare in our rural underserved areas. I urge the committee to support Assembly Bill 364 as it increases access to healthcare all throughout the state of Nevada and helps the healthcare shortage. Thank you so much for your time.
Good afternoon, Chair and members of the committee. I'm Joan Hall, representing Nevada Rural Hospital Partners. NRHP is the 13 rural and frontier critical access hospitals in Nevada. And of those 13, they have 17 rural health clinics. Rural health clinics is a certification that the federal government has and requires nurse practitioners or PAs to work in those clinics at least 50% of the time. While some of our supervisory physicians disagree with independent PA practice, I need to put that on the record, the majority of them agree that the time involved to do the chart checks, to review medications, is probably time lost in seeing patients. They feel that the PAs are doing a great job. They do work collaboratively. If PAs have a patient that needs more care or a different level of care, it's the physician who's going to see them. I see this the same as the paradigm shift when we looked at giving nurses, APRNs, independent practice. It was a struggle. We need to stretch our limits. We think that this is a good bill. Please support this bill. Thank you.
Chair Marzola, members of the committee, my name is Connor Kane, CONNORCAIN, testifying on behalf of Touro University, Nevada in support of Assembly Bill 364. We thank Assemblywoman Cohen for bringing this bill to help create increased access to care for Nevadans, and Touro has a program of physician assistant studies that it's very proud of, and they're excited that the profession could be moving forward. Thank you.
Is there anyone else in Carson City wishing to provide testimony in support? I don't see anyone. Broadcast, is there anyone wishing to testify in support to Assembly Bill 364?
If you'd like to testify in support of Assembly Bill 364, please press star 9 now to take your place in the queue. Caller with the last 3 digits, 019, please press star 6 to unmute.
Hello, my name is Layla Berg. Are you guys able to hear me? My name is Layla Berg. I'm a physician assistant and chair of the membership committee of the Nevada Academy of PAs. A couple of years ago, I was excited about a primary care position my recruiter had found serving an underserved population. I was told my 8 years of experience was perfect for this challenging rural population. I speak Spanish and have found this to be a wonderfully helpful skill for people who often don't get a lot of help. It is one of the many reasons that I love to work in this population. I started working in underserved communities when I started as a PA. My passion is to help to educate people who have never been fortunate enough to receive this help, because I know that I can change their lives for the better. For this group of people, a little extra education can change their lives. Unfortunately, the clinic needed a physician to supervise me. They were hoping to find this person at the local hospital. They were never able to find anyone. The clinic changed their search to NPs only. At least a month later, I saw that they were still searching, and they had told me that they were pretty desperate to find someone because they'd been looking for a while. This requirement makes experienced PAs undesirable. Most clinics are no longer physician-owned the way they were when this law was set. If a clinic wants an experienced PA, they need to pay for 2 licenses, the PA and the physician. It doesn't matter if the PA ever needs to talk to the physician, which is often the case. An inexperienced NP will fill the position without the cost of the supervising physician. I began to do what many PAs have already done, research moving outside of Nevada. In the meantime, I took a job at an urgent care where we aren't set up to do primary care, but more than half of the patients seeing me for minor reasons have untreated chronic illnesses. I might be their only chance for intervention. They tell me they haven't seen anyone in a long time because they can't find a PCP, or that it would be 4 months before they could see someone. So they stop trying. If I barely address their problem, the patient will neither understand their condition nor follow up with anyone. Not having PCPs in Las Vegas is causing a lot of health damage. AB 364 will address the supervision issue and give considerably more access to our Nevada communities. Please vote in support of AB 364.
Thank you so much, ma'am, for your testimony. Are you able to spell your name for the record, please? Broadcast.
Chair and members of the committee, my name is.
You can go ahead and begin when you're ready. Please state and spell your name for the record.
Can you hear me?
I can hear you. You can go ahead and begin when you're ready. Please state and spell your name for the record.
Thank you, Chairwoman. My name is Wiz Rouzard. That's spelled Wizrouzard, and I'm the Deputy State Director with Americans for Prosperity here in Nevada, and thousands of activists, and through our grassroots premier organization, we urge you to support this bill. When we talk about healthcare, we seek to expand access to high-quality, affordable healthcare for every Nevadan, which is truly a top issue for many families across the state. And I applaud Assemblyman P.K. O'Neill for highlighting the rurals. These are the communities that are often impacted the hardest, and those families who are least financially fortunate and end up having to wait due to the labor of supply chain issues. The bureaucracy that we've seen throughout the many years have led to this distinct disproportion of services, more importantly, tying the hands of these healthcare professionals who have dedicated their life in ensuring and serving their community. We support legislation to eliminate regulatory barriers restricting medical professionals' scope of practice so these licensed experts can offer more and provide better services to patients. This bill is a step in the right direction. What I believe someone said, is this going to create a two-tier system? I can assure you that this does not create a two-tier system. If anything, it drives the free market principles that's going to lead to a better healthcare industry than any other state. We do need to consider repealing Senate Bill 420 if we do want to ensure that we do not achieve a one-tier system, a one government-controlled healthcare system that most individuals will have to keep competing for those doctors.
Please keep your testimony about Assembly Bill 364.
My apologies, I was making a reference. But in regards to this bill actually does an amazing job in ensuring that all Nevadans, especially those rural communities, get the care that they need. So I appreciate the bill sponsor, Assemblywoman Cohen, for sponsoring this bill. I appreciate the co-sponsors, and I appreciate the members of this committee driving these type of reforms to ensure health care is premier in our state. Thank you.
Thank you so much for your testimony. Broadcast, is there anyone else on the line?
Good afternoon. This is Dora Martinez representing the Nevada Disability Peer Action Coalition. Thank you to the sponsor, Assemblywoman Awesome Cohen, for this bill. As a member of the Disability Peer Action Coalition, we 100% support this bill. Some of my members are underserved. They live in, some of them live in Elko and Eureka, and we had to fundraise for them to have a driver to come into town to Reno to seek doctors because they can't find it in the rural area. So thank you so much and have a great day.
Thank you for your testimony. Broadcast, is there anyone else on the line?
Chair, there are no more callers in support at this time.
Thank you. We will move to hear testimony in opposition to Assembly Bill 364. Is there anyone here in Carson City wishing to testify in opposition? Please state and spell your name for the record, and you have 2 minutes each.
Thank you, Madam Chair, members of the committee. My name is Sarah Watkins, Watkins, and I'm here on behalf of the Nevada State Medical Association in opposition to AB 364. AB 364 is a disruption of the healthcare team. Our association more than understands the provider shortage in Nevada. And the need to increase access to care. However, the quality of care is just as important and the passage of AB 364 could affect the quality of care provided to patients in Nevada. We understand that physician assistants are an important part of the healthcare team, but they cannot replace the training and education that a physician has. Thank you for your time.
Hello, everyone. I'm Dr. Bayo Curry-Winchell. For the record, I'll spell it. It's quite long, so bear with me. Curry-Winchell. My first name is Bayo. Move this down. Hello, my name is Dr. Bayo Curry-Winchell, and I'm a native Nevadan, previous physician assistant, and currently a board-certified family medicine physician who also practices urgent care, as well as a medical director. I'm here to share my concerns with the upcoming physician assistant bill, which is requesting the removal of physician collaboration and oversight. As a previous PA that worked for 3 years in a wide variety of specialties that included primary care, urgent care, and occupational medicine, I decided to leave the profession and apply for medical school to learn and develop a deeper education and skill set within medicine. It was very apparent from the very beginning of medical school that the difference between the education I had received as a PA and the education I was embarking on was much more significant than I initially expected. Medical school expects a much deeper and extensive understanding of basic sciences, including anatomy, biochemistry, and pharmacology before classes even start. This foundation is then built upon extensively to equip physicians with skills and knowledge and understanding to provide care that can range from simple to the very complex. As an independent agent who owns a patient's care and treatment, the physician assistant name, as the name implies, has a very different expectation. The PA curriculum is founded on the principles of assisting a physician. It uses a curriculum of 2 to 2.5 years to provide the cliff notes on basic medicine to help the PA work alongside a physician. This is in contrast to the physician curriculum, which is a minimum of 7 years of medical school. That includes direct patient care through a residency program. The PA profession, even with the years of experience, does not equate to the same education and skill set as a physician. I have experienced both professions and can unequivocally state there is a significant difference in medical knowledge and skill sets. The role of a supervising physician was established because of the gap in medical knowledge and experience. If removed, this would greatly affect the quality of care given to patients and potentially put PAs in a situation that they are not equipped to take care of. So in the end, I'd like to share, I think this is a good bill, but there's concerns in respect to the difference of knowledge. And so I think there's work to be done as far as what we can do to improve access, but make sure that we don't discount quality.
Doctor, thank you so much for your testimony. I was going to ask you to wrap it up, but you did. Thank you.
Thank you, Madam Chair. For the record, Susan Fisher with McDonald-Carano, speaking on behalf of the Nevada State Board of Osteopathic Medicine. The proponent spoke about the collaborative model, the team model. We're very committed to having the team model. We know that we need more physician extenders. We need more physicians, period, in this state. But the physician extenders, the PAs and other mid-level providers are very, very important, but we need to make sure that we have the appropriate level of supervision. NRS 633-469, I think, helps solve some of the problems that was put into statute a couple of sessions ago that says that the supervision only has to be, at least with the osteopathic chapter 633, that the supervision in person only needs to be within the first 30 days. After that 30 days, it can be telephonically, electronically, by web. So the physician does not have to be there in person, and that helps solve some of the issues that the rural hospitals have, or even urban hospitals where you may not have a physician on site. The physician may be out of the office at the hospital, but they're still available by phone and electronically. And also that chapter does not apply to the FQHPs, so they do have other exemptions as well, the federally qualified health providers. So for those reasons, we do oppose this bill at this time. Thank you.
This is Sarah Bradley on behalf of the Nevada State Board of Medical Examiners. So the Nevada State Board of Medical Examiners subcommittee has voted to oppose this bill, and a summary of the reasons are as follows. First, there's a concern for patient safety due to the tremendous increase in autonomy for physician assistants without any significant increases in education or training to offset that. The second concern is that adding 2 physician assistants to the board would be a large representation in terms of percentage when compared with the number of physician assistant licensees. Third, we have some questions about the collaboration and what that will or should entail in the proposed bill. There's not a definition, and perhaps maybe that's something that can be addressed later. And then the last concern is that we have some questions about whether a physician assistant would need a new collaboration when switching specialties. So in other words, if they did the 4,000 hours in dermatology, for example, and then wanted to work in psychiatry, would there be another 4,000 hours required? So those are our questions. We do look forward, though, to working with the sponsor and the physician assistants to potentially work out these issues as the process continues. Thank you.
Thank you for your testimony, but before you get up, Assemblyman O'Neill has a couple questions.
Okay.
Thank you, Chair, for allowing me this. I appreciate what you're saying, and I appreciate your last comments, Pat, working with the sponsors on this bill on your questions. But I have a question for you, if you can answer it. You said that the first concern that the physicians have is the independence of the PA. Was that, run that one by me.
It's almost a direct quote from the subcommittee. It was.
And can you state your name for the record?
Sorry, Sarah Bradley, Deputy Executive Director for the Nevada State Board of Medical Examiners. The concern is for patient safety due to the tremendous increase in autonomy for the physician assistants with this proposal without any significant increases in education or training that offsets that autonomy.
Thank you. So going with that statement, when, as has already been testified by our PAs, that they're heading up units, they see their doctor for a few hours in a 30-day month, that she may be out someplace else. Even from the prior testimonies, that the PA can be working in Nye County and the supervising physician can be in Reno. I'm having trouble grasping that concern when they're separated by miles, talking on a telephone, seeing each other once for 4 hours every 30 days. Are you able to go in a little more detail, that concern for me, please?
Sure. Sarah Bradley, Deputy Executive Director. I can at least tell you what the requirements are, if that's helpful. So the requirements are, yes, that the supervisor spends part of one day of every month with the physician assistant. They also are supposed to develop a program of supervision that usually entails reviewing a certain amount of charts, things like that. Part of that observation once a month is making sure they observe the conversations with patients, referrals that are made. There's a list of things in our regulations that they should be observing in that meeting. And then, of course, anytime the physician assistant is working, they would be available to consult by telephone. One thing that I think wasn't mentioned earlier, and it might be helpful, they can have more than one supervisor, so they can have a substitute or a secondary supervisor for when their primary is not available, so that they can keep working if they're gone.
And if I may, please, pretty please, yes, ma'am. I appreciate that, but I was here in 2015 when the APRNs were given some of this freedom to practice, and I don't quite remember the physicians having these concerns. And if they did, I don't see some of the problems having come forth with the APRNs working independently as they have over the last several years. So I appreciate it. I appreciate your statement. I look forward to working with you and Assemblywoman Cohen on these issues, and hopefully we can find resolutions, because it's a necessary need that we have. This is a need we have for all of Nevada, the rurals and locals. Thank you. Thank you, Chair, for allowing me this exception. I appreciate it.
And thank you for taking the time to answer some questions. Is there anyone else here in Carson City wishing to testify in opposition? I don't see anyone broadcast. Is there anyone wishing to testify in opposition to Assembly Bill 364?
Thank you, Chair. We have no callers wishing to testify in opposition at this time.
Thank you. We will move on to neutral testimony. Is there anyone here in Carson City wishing to testify in the neutral position to Assembly Bill 364? I don't see anyone broadcast. Is there anyone on the line wishing to testify in neutral to Assembly Bill 364?
We have no callers wishing to testify in neutral at this time.
Thank you. Assemblywoman, would you like to give some final remarks?
Thank you, Leslie Cohen, Assembly District 29. I'd like to turn it over to the stars of the show, the PAs.
This is Ben Prohaska, for the record. We understand the language collaborative, independent, autonomously. I already work autonomously. I mean, again, I saw patients this morning by myself, and I didn't leave each patient and then go call the provider, the practitioner I work with. I have a breadth of medical knowledge that I've developed over 17 years. We don't learn how to be a practitioner in school, just as physicians don't learn how to be a practitioner in school. They learn how to do it in residency. The 4,000 hours came about because that's what this body gave the APRNs several years ago. And that's where we came up with the 4,000 hours, to bring our profession back to where the APRNs are at, so that we too can get those jobs that the hospitals are offering. We're not looking to not work with physicians. My physician and I, we talk at lunch about patients. We just sit down and we chit chat, like, am I doing the right thing on this patient? What would you do? And they're like, sometimes you just need to talk through an issue with someone else and you already have the answer. You just want someone else to say, yeah, that sounds reasonable. PAs are not looking to open practices tomorrow. If you look at physicians when they graduate residency, no one's opening lots of practices. It's not feasible. We all work for hospitals. We all work for clinics. When the APRNs were given independent practice 6 years ago, there hasn't been an uptick in lawsuits. There hasn't been an uptick in nurse practitioners looking or having malpractice suits. In Utah, this bill mirrors some of what Utah has. And when they did this several years ago, there hasn't been an uptick in PAs with malpractice suits. And so that's what we're looking at. We're trying to uncouple a couple state laws that were made 30 years ago so that I can practice the way I currently practice, which is already autonomously. I love having a physician to talk to. I like having other PAs to talk to. I like having other nurse practitioners to talk to. I don't think any of us are looking to work on our own. I think that's...
Carmela Downing, for the record. I'm not aware of any studies showing poor outcomes when supervision agreements change within the state. I agree with everything Ben says. We are certainly not looking for independence. Independence is not a word we use. We work very closely with collaboration. And I wish I'd have brought my collaboration agreement that we have at Carson Tahoe, as it lists almost verbatim the requirements in 630 and 633. I ask you to support this to bring PAs more up to speed. As a recruiter, it is currently not equal of how we can hire and employ PAs and APRNs. And so I ask you to support this bill. Thank you.
Thank you. Thank you for your presentation and for bringing this bill forward. I will now close the hearing on Assembly Bill 364. I will now open the hearing on Assembly Bill 442, which requires the Board of Medical Examiners to take certain actions in response to certain complaints against a licensee. Assemblywoman Peters, you may begin when you're ready.
Thank you, Chair Marzola and committee members. For the record, I'm Sarah Peters, representing Assembly District 24. I'm grateful. I was approached by a constituent regarding this issue and asked, what can we do? The issue at hand had to do with a well-known physician in Reno who had harmed this constituent while under his care, damaging her both physically and emotionally, leaving impacts on her daily life. In addition to her story, there were dozens of other similar stories, accompanied with complaints lodged with the medical board or the Board of Medical Examiners, and follow-up with law enforcement, all of which appeared to go unanswered. In looking into this was something that is in the news across the country, and the most disturbing news recently coming out of Utah is that the Utah Supreme Court ruled that a criminal case taken against a physician in in their state, accusing the physician of sexual assault of the patient, was determined to not be applicable to criminal law and was cited to be under the jurisdiction of medical malpractice. So I went digging and approached the Board of Medical Examiners and approached law enforcement and asked them, what happens when a patient is assaulted on an operating table and they make a complaint? Both entities take this very seriously. It's a criminal allegation, right? A criminal complaint. It is an abuse of power, an abuse of license. Both entities take this very seriously. However, these constituents, their issues were not being resolved. The physician is still practicing medicine, despite the dozens of complaints against him. So we dove in. What can we do? How do we have law enforcement work with the Board of Medical Examiners to ensure that the path forward has resolution for these victims? What you have here in front of you today, Assembly Bill 442, is the beginning of the conversation of what can we do. We talked about parallel paths, right? So the Board of Medical Examiners taking a complaint that has a criminal allegation in it on a path through their investigation process. We additionally have the law enforcement take a path of criminal investigation on a criminal allegation, right? And so we had to figure out how to bridge those. How do we have the Board of Medical Examiners and law enforcement talking to each other to know what their findings are and what the process is looking like? We have a draft amendment. I don't know if it made it into the record yet because we're still continuing to work on this. But the goal of the language will ultimately be ensuring that our law enforcement and the Board of Medical Examiners talk to each other about where they're at in the process of reviewing complaints from patients with criminal allegations, and how that resolves with that physician's license, right? Whether they retain the license or that license is removed, and the restitution for the criminal conduct, potential criminal conduct of that physician. I have with me to help present on this the Sarah Bradley, who's with the Board of Medical Examiners, and that I would ask that she talk a little bit about what their current process looks like and what it was that we identified being kind of needed to infill this space to make sure that we have an appropriate management of these types of complaints.
So Sarah Bradley, Deputy Executive Director for the Nevada State Board of Medical Examiners. We do our best to communicate with all parties that might be relevant to a case, a complaint that we get, and we do a lot of referrals, whether it's to other government agencies or law enforcement. Most of the time, I'm thinking of the most recent cases involving sexual allegations. Our understanding was that complaints had been filed with law enforcement prior to us getting our complaint. So at least in the most recent ones that I'm aware of. Obviously, we don't always know everything that law enforcement might see unless we're told. We do our best, like I said, to communicate with others. We also refer things to the Attorney General's office, not sexually related usually, but like billing fraud and things like that. So we do our best to make sure that not only do we do a comprehensive investigation of what we have before us, that we send information to others regarding that. And I guess I would echo the fact that sexually related maybe complaints and issues, and it's not always an inappropriate, like a sexual assault. Sometimes it's an inappropriate touch, which would be maybe a lesser, or maybe a inappropriate comment. I mean, there's a lot of kind of unprofessional yuckiness, I would say, that we have been seeing that may not necessarily rise to a felony level. But again, we do our best to look at everything before us and investigate it thoroughly and send it wherever we think it might need to go to help. And we would work on it at the same time as them. I don't know if there's specific questions that I should answer on that.
Yeah, I think we're open for questions from the committee.
Committee members, any questions? Assemblyman Yurick.
Thank you, Chair. I like the idea of increased collaboration between the board and law enforcement for sure, especially in light of some of the instances that we've seen. It is, as you said, yucky. My question is in section 3 on page, I think it's 4. I keep having pop-ups here. Yeah, so it's at the bottom of page 4, starting on line 37. It's the new addition that basically now requires, so let me back up a little bit. On line 28, subsection 3.1 provides that if the board determines that there's a felony, somebody's at risk, that they can suspend the license already. And it looks like we're adding a new subsection 2 that says that's going to mandate the board to suspend a license based on a subsequent allegation that's substantially similar. And so I think I understand what the intent is, but what I want to try to do is clarify, because I'll even quote the words of one of my colleagues in an earlier session. Just because you're accused of something certainly doesn't mean that you're guilty of it. Would this apply to a scenario where, let's say, hypothetically, 2 people are going to conspire to crush this doctor, and so one person makes this baseless allegation, but there's whatever reason gives enough detail that it warrants an investigation, and certainly the board under subsection 1 there could suspend if they determine to be some a reasonable risk, right? What if they conspired with somebody else to a week later make a similar allegation? 2 people making the allegation. Would that apply to this and mandate an immediate suspension of the license, or is this indicating a prior investigation that is substantially similar?
Sarah Peters, for the record, I'm really glad you asked this question. We have been working together with physicians, right, in consultation with physicians on what is the best way to address this particular issue. And Sarah, sorry, Ms. Bradley can correct me if I'm wrong. The Board of Medical Examiners are a board of physicians who help regulate the licensed physicians in the state of Nevada. And in some cases, it gives having a may is not enough support for that body to make a decision against somebody who has a power in the community, right? Because we are a small community of physicians. So our goal was to give them a backstop that says if there is a case in which there are felony complaints of a certain nature, we're defining certain nature as sexual assault or domestic violence, and then the goal in a revision, an amendment we're working on, is to give the regulatory authority to the board to define any other particular situations in which they would have to remove the license, and then give them the regulatory authority to define the process for that. Because I think it's also important that we look at the scenarios that can occur. To your point, when is it appropriate, right, to remove that license? Is it upon a specific type of finding in an investigation where there's enough evidence that it is just it's apparent we have to remove that license to protect the public? But I think that it's better defined in regulations than it is in statute. So my goal with the amendment is to put that is to amend this section so that it is giving regulatory authority to develop that process out, while also giving the backstop of you have to find a process that definitively allows you to remove a license for specific felony conducts, but that process has to have these steps, these transparent steps, so that there is due process for physicians in the event of exactly what you're talking about. There's a conspiracy against a physician for something that's not a felony, an actual felony that's been conducted. Yeah. So I apologize. We are in session, running with our hair on fire, trying to get things drafted. And so I apologize that I do not have a functional conceptual amendment in front of you today. But I want to assure you we are actively, vigorously working together on finding a way to make this work for everybody. I don't know if Ms. Bradley has other comments she'd like to make.
Sarah Bradley, for the record, I would just echo those comments, and we have the same concern that you're raising, Assemblyman Urick, just that we would want to make sure that whatever complaints we're taking action on are credible and fully vetted. And so that is a concern the board has as well. We take both our public protection and there's all kinds of reasons potentially someone could be summarily suspended if the health, safety, and welfare of the public required it. So we take that very serious, but we want to make sure we only do that in appropriate situations. I can tell you I have been working in administrative law with licensing boards for almost 16 years, which is kind of amazing it's been that long. I've only done a handful of summary suspensions in my career because it's usually a rare thing. It's usually really egregious bad conduct, and usually there's kind of no question. And so I think what's good about this in some ways is it would give us a little bit more of a bolster on some of these that are maybe harder to prove but still really serious, but it also still allows us to vet carefully to make sure someone's not abusing the process, because of course we do not want that at all. We just want to help keep the public safe the best we can.
Committee members, any additional questions? I don't see any. Are you done with? Assemblywoman Duran.
So you were just basically, and thank you for the presentation, because it is a serious allegation for these, and it can ruin a doctor's or a physician's life. So is there any thought about the complaints as the amount of complaints against a person? Because I know some can be unfounded, and is it same in nature? Are you taking into that consideration as well?
Sarah Peters, for the record, I think the balance that we're trying to strike is the integrity of the institution, right? Our medical institution and our physicians. We want to ensure that we are protecting those who are doing the job of a physician in the ethics that is required by that position. But we have to find ways to protect the public, and I believe. We were going to have some testimony provided by a victim. She is uncomfortable with sharing her name because of what has happened with her. However, in her case, the physician was taking advantage of Medicaid patients who were non-English speaking. And that is a demographic that we don't cater to in the best way for within law enforcement or within the advocacy process. And so there's also a balance of making sure we're protecting vulnerable populations from predators while maintaining that integrity of the institution. And I think the physicians can speak to this. It's important. It's an imperative that we protect the medical institution, that people can trust their physicians, right? But when we are not taking action on physicians who are conducting these egregious actions against people, especially those who are the most vulnerable, we're not doing that justice, right? So our hope, my goal, is to develop a process that allows for that balance to be struck while allowing for some deference from the entities who know best what is happening in the industry, with a check on coming back to the Ledge Commission, right, so that we can kind of have a touch on making sure those regulations are strong enough to actually support those decisions being made, but while also seeking the input from physicians to ensure that we're striking that balance for them.
And I appreciate that, because there is many people that don't come forward because of the same situation, that they're vulnerable. They feel that because they don't speak the language that nobody believes them and stuff like that. So I appreciate that, if there is complaints, even anonymously, that, they take that into consideration as well. Thank you.
Thank you for bringing that up, Sarah Peters, for the record. I also think that it's imperative in those instances that we have these communication tracks, right? Because there may be a potential criminal case where the victim doesn't want to pursue criminal charges, but that record is still in the law enforcement institution, right? So if another person comes in with a similar case, they can see that there's a trend with that particular person. And similarly, for the Board of Medical Examiners, if they're getting complaints that are not getting vetted into the law enforcement because of the same concerns, they don't want to bring a case against the physician, that they can say, hey, this guy's a bad actor. Like, these women may not want to charge him with criminal activity, but the least we can do is strip him of that license so that he can no longer harm that population.
Any additional questions? I don't see any. So what happens when you present a bill at the end of the day? We will now move to testimony in support of Assembly Bill 442. Is there anyone here in Carson City wishing to testify in support? Please state and spell your name for the record.
Good afternoon, Chair, members of the committee. My name is Serena Evans, SERENAEVANS, and I'm the Policy Director for the Nevada Coalition to End Domestic and Sexual Violence. Today I am here on behalf of numerous victim survivors who have allegedly experienced reproductive coercion, medical mutilation, and sexual assault at the hands of a prominent OBGYN here in Northern Nevada. I say allegedly not because I don't believe them, but because our current pending investigations have taken far too long to conclude any final findings. I want to thank Assemblywoman Peters for listening to the heartbreaking stories of these victim survivors and for taking action and bringing this bill forward. Never in my time as a domestic and sexual violence victim advocate did I think I would be involved in the Board of Medical Examiners procedures. However, our current systems have seemingly failed victim survivors going back over 20 years, which is why I sit before you today. NCE DSV was approached by a large group of women seeking justice against one particular doctor. This group of women has submitted more than one complaint filed through the Board of Medical Examiners claiming unnecessary procedures, sexual assault, botched surgeries, medical coercion, and Medicaid fraud. We have heard that these women tried to pursue actions through law enforcement, but were told that they do not have jurisdiction, and their complaints through the board have taken an uncomfortable amount of time to review, despite multiple complaints. All the while, this doctor is still practicing and likely harming low-income and marginalized communities. We are taught to trust our doctors, but this is a blatant abuse of power and control, and there must be accountability for stopping ongoing harm in our communities. Working with the victim survivors, I have heard horror stories that have made me sick to my stomach. Repeatedly, these victim survivors have pleaded that if they could do one thing, it would be to stop this doctor from harming more patients. The fact that there are multiple open complaints against the same doctor and they have still been allowed to continue to practice while the board is taking as many as 4 years to review these cases is extremely problematic. There needs to be some form of accountability for doctors harming, harassing, and assaulting their patients. Many of these victim survivors want to share their stories, but because of their vulnerability and their experiences and the power that this high-profile doctor carries in our community, they are fearful of sharing them on public record. And on behalf of those too fearful to speak their truth to power here today, we urge the passage of AB 442. Thank you.
Thank you so much, Madam Chair, members of the committee. Dylan Shaver, DYLAN SHAVER of Pinion Public Affairs, here on behalf of a group called Empower Nevadans Now. Empower Nevadans Now is a victims advocacy group that focuses on people who have been the victims of abuse across Nevada's medical system. This isn't about sort of, I think we all love our individual doctors, but we all know that anywhere there's bad actors, right? And unfortunately, over the year, the legal framework that regulates all of that has allowed some folks to get away with some pretty awful things. I am by no means as eloquent as Ms. Evans before me. Nevertheless, I think we are all aware that there are some serious challenges in Nevada's healthcare system, and that we all, from both a policy perspective, from a community perspective, and from the profession itself, I think we all want to see something better. And it is important to remember the role accountability plays in improving any system at all, whether it's a healthcare system, whether it is a shop you run. The way to get to quality is to hold people accountable for it. And while that is often uncomfortable and often comes with risks, Empower Nevadans Now would like to thank Assemblywoman Peters and the supporters of this measure for taking a brave first step, and we look forward to doing what we can to make sure these victims' stories are told and that they have a path to justice in the near future. Thank you so much for your time.
Good afternoon. For the record, my name is Sarah Watkins. I represent the Nevada State Medical Association here in support of AB 442. As a patient-physician advocacy association, we always want the patients to be protected and heard. And we appreciate the opportunity to work with the Assemblywoman and the Board of Medical Examiners with the added amendment that allows for the Board of Medical Examiners to establish regulations around due process, timeframes, and complaints. And we thank Assemblywoman Peters for bringing this bill forward. Thank you.
Is there anyone else wishing to testify in support here in Carson City? I don't see anyone. Broadcast, is there anyone on the phone wishing to testify in support of Assembly Bill 442?
Chair, the public line is open and working. There are no callers at this time.
Thank you. We will move to testimony in opposition to Assembly Bill 442. Is there anyone here in Carson City wishing to testify in opposition? I don't see anyone. Broadcast, is there anyone on the phone wishing to testify in opposition to Assembly Bill 442?
Chair, there are no callers at this time.
Thank you. We will now go to our testimony in neutral. Is there anyone here in Carson City wishing to testify in a neutral position to Assembly Bill 442? Please state and spell your name for the record, and you have 2 minutes each.
Good afternoon, Chair Marzola and Assembly Committee on Commerce and Labor. My name is Chris Reese, R-I-E-S, and I represent the Las Vegas Metropolitan Police Department. We are neutral this time, but are working with Assemblymember Peters and are hopeful to move to a position of support. We feel this is valuable and important legislation, and thank the Assemblymember for her work on AB 442. Thank you.
Good afternoon, Chair, members of the committee. Jason Walker, Jasonwalker, Washington County Sheriff's Office, testifying in neutral to Assembly Bill 442. Certainly willing to work with Assemblywoman Peters to help bridge any gaps. Thank you.
Thank you for your testimony. Is there anyone else here in Carson City wishing to testify in the neutral position? I don't see anyone. Broadcast, is there anyone on the line?
Chair, the public line is open and working, and there are no callers at this time.
Thank you, Assemblywoman. We will now close the hearing on Assembly Bill 442. I will now open up for public comment. Please address your remarks to issues that fall within the jurisdiction of this committee. Public comment is limited to 2 minutes per person. Is there anyone here in Carson City wishing to provide public comment? I don't see anyone. Broadcast, is there anyone on the line?
Chair, the public line is open and working, and there are no callers at this time.
Thank you. This will conclude our meeting for today. Our next meeting will be Friday, April 7th at 12:30. This meeting's adjourned.